You're listening to High Frequency Radio. I'm your host, Yusef L. It is Monday, September 7, 2015. I'm broadcasting live from Atlanta, Georgia. Happy Labor Day weekend. I hope y'all had a good weekend. It was really going down here in Atlanta. It was off the chain in Grant Park yesterday in Atlanta. Got a real good show lined up for you today. Today, I am going to talk about criminal cases again, using your attorney. You know, a lot of people, they are under the misconception that having a public defender is a bad thing, and I'm here to dispel those misconceptions. You got to know what a public defender is, y'all. A public defender is just like the name says. He defends the public, and you're not the public. He defends the public. He's defending the straw man, not you. You're a private citizen. Get out of the way and let him do his job. Now, on my website, I have two documents that detail this information very well. And I'm going to begin the show today by reading one of those documents. And the name of the first document is using, what is it? Hold on, let me show y'all what it's called. Using the attorney for private rights. It's under the PDF section of my website. Under commercial. And this is and the reason I like this document because it's not very long. It's very, very short. And it has a very, very good letter of instruction to an attorney in this particular document. Now, let me give you some background before I read this. Now, when you're in a court proceeding, I hope by now everybody realizes that the name on the paper is the straw man. It's not you. It's this trust account. This constructive trust is what it's called. And if it's trust, then you know it's equitable because that's the only place trust can be enforced. Right solely enforced in equity. All right? Which is why you need to have an administrative process and you need to come through an agreement of the parties. You need a contract to be ruled on. That's why, you do the administrative process. Now, you're going to complete an administrative process prior to giving an attorney any instructions because you have to do everything in the spirit of Matthew 5:25 where it says, agree with your adversary while you're on the way to court, lest he hand you over to the judge hand you over to the bailiff, and the bailiff cast you into prison. I tell you, you will not come out until you pay the very last farthing, and farthing means penny. So you pay the very last penny. All right? Now, that principle is still in operation in effect today. Okay? You have to understand that you need an agreement with the fourth of the parties before you go into court. This is a stipulation. This is what they call in law a stipulation. You have to stipulate with the opposing party. The way that you come to a stipulation, an agreements are either implied or expressed. Let me stop right here and look up the word agreement for you, okay? Because a lot of people they think, well, what do you mean? Get an agreement? They don't agree with me. All this kind of stuff. So let's look up this word agreement because we cannot presume or assume that we know the definition of words. We have to approach this. And that's the way I did. I approached this thinking to myself I had to re-educate myself totally. All right? And that's what you're going to have to do. You're going to have to re-educate yourself on these matters. So when we look at this, and we go in, and we get a Black's Law Dictionary, 8th edition, and we look up the word agreement. Let's look up the word agreement first. Let's look that up. What is an agreement? Okay, I'm coming out of Black's Law 8th edition. I'm using an 8th this time. And on page, I found it, agreement, page 209, Black's Law 8th edition. Let's read this. we need to understand what an agreement is, because in the Bible it says agree with your adversary. So we need this. First of all, we're going to start with, well, what is an agreement? We're not going to assume, that we know what the definition of the word is. We're going to take the time and look it up, and then we're going to get us some flashcards. And every time you look up a word the first time, you're going to write that word down on your flashcard on the front, and on the back, you're going to write the definition by hand, as much of the definition as you can get on the back of the card by hand. And you're going to wake up every morning, and you're going to read that flashcard and any other flashcards that you've done the same thing with until it seeps into your mind that you understand what that word means. So here we have agreement, a mutual understanding between two or more persons about their relative rights and duties regarding past or future performances, a manifestation of mutual assent by two or more persons. Number two, here's the second sense of the word. The party's actual bargain is found in their language or by implication from other circumstances, including course of dealing, usage of trade, and course of performance. Now, did you see right here where it says implication from other circumstances? And then it gives you, funny enough, right here in Black's Law Dictionary, it gives you UCC 1-201B3, and then it gives you corpus juris secundae under contracts, chapter 2, 3, 9, and 12, paragraphs 2, 3, 9, and 12, under agreement. Now, and if you don't know what a corpus juris secundae is, you can, it is an legal encyclopedia that you'll find in most law libraries. Now, let's look up UCC. This is interesting. Let's look up UCC 1201B3, all right, because this is what it tells you in the Black's Law Dictionary. It tells you to go to the UCC and look it up right out the Blacks. And Blacks will do that a lot. Blacks makes reference to the UCC a lot, So let's look at it. Let's see what that's saying. UCC 1201B, it's under general definitions. B3, as distinguished from contract, means the bargain of the parties in fact, as found in their language or inferred from other circumstances, including course of performance, course of dealing, or usage of trade as provided in Section 1-303. Now, this is interesting. Right there in your Black's Law Dictionary, they pulled the definition straight out of the UCC. I find that to be very, very interesting. Okay, now let's look further. Okay, we're going to look further into this. Let's look further into it. And let's look at the different types of agreements that we have, okay? Now, first, let's start with the expert commentary that's under that. It says, the term agreement, although frequently used as synonymous with the word contract, is really an expression of greater breadth of meaning and less technicality. Now, notice that in the UCC, they do make a distinction between contract and agreement. Notice that under UCC 1-201B3, they make a distinction between that. All right. Now, every contract is an agreement, though, but not every agreement is a contract. So every contract is an agreement, but every agreement is not necessarily a contract. Okay. It is colloquial in its colloquial sense, and colloquial means like street. Colloquial sense, the term agreement would include any arrangement between two or more persons intended to affect their relations, whether legal or otherwise, to each other. An accepted invitation to dinner, for example, would be an agreement in this sense, but it would not be a contract. Okay, they're giving you the examples, because it would neither be intended to create, nor would it in fact create any legal obligation between the parties to it. Further, even an agreement which is intended to affect the legal relations of the parties does not necessarily amount to a contract in the strict sense of the term. For instance, the conveyance of land or a gift of a chattel, though involving an agreement, is not a contract, because its primary legal operation is to effect a transfer of property and not create an obligation. Second Stephen's Commentaries on Laws of England. Okay, now let's look at some other expert commentary. It says, an agreement, as the courts have said, is nothing more than a manifestation of mutual assent by two or more legally competent persons to one another. Agreement in some respects agreement is in some respects a broader term than contract, or even than bargain or promise. It covers executed sales, gifts, and other transfers of property. All right. Now, agreement to agree. Although this is funny. Okay, so let's look at they got other kinds of agreements. So did you see where it says from your implied circumstances or implication from other circumstances? So there can be an agreement that can be implied from your conduct. Now, I want to look up the word next, implied contract. Write these down. Because everybody was always talking about contract, and if you were listening to my last shows, every contract does not require offer, acceptance, and consideration. Gifts do not require consideration. You know, when somebody calls me when I'm on the air, it's kind of disrespectful because it just lets me know. I mean, you don't really listen to me. You should always know that I'm on the air on Monday. I mean, why would you call me and I'm on the air? You know, it's like it's kind of disrespectful. This is what makes you mad. I'm like, damn, you know I'm on every Monday at this time. Why would you call me? You know I'm on the air at this time. I mean, I don't understand that. It's kind of like people when like I send them, you know, the webinars, and they said, I didn't get my link for the webinar. And I said, did you look at the receipt? I mean, it's right on the receipt. The link for the webinar is right on the receipt. And you didn't read the receipt. I mean, that's interesting. But anyway, let me get back to implied contract. And it's under contract. And you go to page... And I was on a call one time with some more who were like, you know, telling me my information was old and stuff. I was like, really? They didn't know me and everything. They talking about, well, what contract have I entered into? They were on there talking about. Now these were some Moors, and they had some chick. She was supposed to be like a grand sheik or something like that, and she was trying to teach them how to, you know, file some unemployment disability or something on the job. And I'm like, you know, I'm listening to it. I'm like, so then, you know, I kind of like was talking. I'm like, well, why are y'all on here talking about this? And, you know, of course, they went off on me and everything. And I would say, well, you know, I started talking about contracts, and, you know, well, what contract am I in? We're not under any contract. I was like, okay. All right. Do you understand the different types of contracts that there are? You know, every contract, you know, have you studied contract law before you open your mouth? Because all they hear is offer, acceptance, and consideration. You know, you see it in all the documents. I have no offer, acceptance, and consideration with you. This was fraudulent. It's unconscionable. You know, and I'm like, you need to really get into contract law and understand the different nuances of that sphere of law before you begin opening your mouth, because you're going to find that a lot of things that you thought were wrong. And contract. So I'm at contract. Now let's look at contract. It says an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable as law. So a contract is an agreement, like I said earlier, but not all agreements are contracts. So we're trying to create a contract, which is an agreement. So let's look at the word implied contract. And that's on page, I mean, they got a million types of contracts on here. Okay. Implied contract, it's on page 979 in Black's Law 8th edition. Implied contract, an implied in-law contract, an implied in-fact contract, which is opposite of express contract. Now, implied in fact contract is a contract that the parties presumably intended as their tacit understanding as inferred from their conduct and other circumstances. Also termed contract implied in fact. Okay? So here we have it. All right? It is from your conduct. Let's look at something else. Implied in law contract, an obligation created by law for the sake of justice, specifically an obligation imposed by law because of some special relationship between them or because one of them would otherwise be unjustly enriched. Okay, this is a constructive trust. Okay? An implied in law contract is not actually a contract, but instead a remedy that allows the plaintiff to recover a benefit conferred on the defendant, also termed contract implied in law, quasi-contract, constructive contract, see unjust enrichment, and cases implied in constructive contracts. This is just almost the same thing as a constructive trust. Now, look at this. Adventurous courts have turned to the idea of a contract implied in law, a quasi-contract, not really a contract, a legal fiction necessary to promote the ends of justice and, in particular, to prevent unjust enrichment. And this is what, a constructive trust is. This is almost exactly the same definition of a constructive trust. So we already know that there's some sort of contract when you go into court, because that is the only way that they can bring you into an Article I court. Now, in the old school, we used to say, well, where is the contract? Put the contract on the record. They're never going to put a contract into evidence because there is a presumption. Everything that they do is presumption, assumption, and color of law. So it's implied contract, and it's been based off of your conduct. And you do the same thing to them. Through their conduct, through their silence, they have an implicit agreed to the contents of your correspondence. Silence's acquiescence is a maxim of law, okay? So I wanted to get these agreements because what you want to do is before you go to a public defender, you want to establish some sort of contractual agreement based off of some implied contract or some type of conduct or through which is basically going to be their silence, and you want to get that certified by a notary, and then you want to hand that along with a letter of instruction to your public defender. That's why you tell the public defender, do not argue any facts. All right? He doesn't have to argue any facts because all the facts have already been agreed to. There's a stipulation of the parties, so he doesn't need to argue any facts. So when you hand him that certified certificate of non-response, certified, okay, and you get it and you say, well, look, I've already got an agreement of the parties right here. All I need you to do is to file this. And the next court hearing that we have, I want you to read this into the record, and I want you to ask the judge to discharge the case. And they will meet in private to have those discussions. As soon as you tell them that, there ain't no attorney-client privilege, all right? As soon as you tell him that, he's going to run and go tell the prosecutor and the judge and everybody else. Everybody's going to know what you're doing. So, they talk that shit about, well, we got to keep this between ourselves. But no, they work for the public, and they're going to stick together, okay? So I want you to understand that you want an agreement, and then you want to go and file it. If he does not file it, you go and file it, and you file his instructions, and you get a stamped copy. You always get 3 stamped copies of anything that you file with the clerk. You need a copy that's going to go into the evidence file. You need a copy to bring with you to court, and you need a copy to put somewhere in a safe place in case something happens to the other 2 copies. But you want stamped copies, original stamped copies. You do not want to go and make a photocopy of it. You want to take all 3 of the copies up there to the clerk's office and have the clerk stamp all 3 of them fresh and put a little signature on them. You want originals. You want 3 originals. All right, so now you have an agreement or stipulation. Okay, if there is any argument, whenever you go in there and argue, see, a lot of guys out there telling y'all to argue jurisdiction. You don't have jurisdiction over me. Since day one, I've been saying that is a fallacy. It never works, by the way. Nobody ever wins arguing jurisdiction. Nobody. Why would you? The definition of insanity is to keep doing the same thing over and over again, hoping for a different result. There are a lot of people. I was in my chat room the other day, and somebody was talking about somebody had a court case. Well, this guy right here seems like he really, really understands this, and he lost. And I'm like, well, that's what's called an off-point argument. You can go in there and demonstrate all the knowledge of law that you want to, but it's an off-point argument because you're not there talking about what matters. You're talking about something else. Okay, this is unimportant what you're talking about. It doesn't have anything to do with the issue at hand. And y'all can see that if you go into my forum section under negotiable instruments, there is a discussion in there under negotiable instruments. That was a real interesting discussion in the forum section of my website. I'm going to put it in the chat room in case anybody's going over there and wants to look in it. There you go. Now, so you want to have what is called a letter of rogatory. A letter of rogatory. I called it a letter of instruction because a letter of rogatory is instructions from one court to another court. And basically, you're holding your own court. Court is held on paper. You have court, and then you have a courthouse. House. The court is the paperwork. Okay? It is not the place. When you go into the courthouse, that's something different. Okay? That is something different. So you have court. Court is held on paper. You know, I try to tell a lot of people who they come to me, and the first thing they do, well, I called down there and everything, you know, and I spoke to the clerk, and I spoke to, some other people down there, and they told me, and immediately I stop them. Or they say, I called the bank, and they're supposed to be doing a modification for me. I spoke to Miss Johnson in such and such department and everything, and I'm just shaking my head the whole time. And I was looking, I'm like, wow, they really got our ass, because they got us to understand. He's like, we don't like to write anything. And there's a maxim of law that says the written word remains forever and the spoken word flies out the window. If you don't know what that means, the spoken word flies out the window. That means is anything that you say, it don't have no standing in law. It's hearsay. Okay? You have to have something factual. You have to put it to pen and paper, put it in ink and put it on paper. I don't want to hear what you're saying with your mouth. Like, for instance, some people say, I was in court. And the judge said, well, this is an Article 3 court. I said, well, show me that in a transcript. Show me in a transcript where a judge said that this is an Article 3 court. I mean, it's our people don't think. It's like, man, it's not in writing. A judge tell you anything. You ain't got no evidence he said that. You come back telling me what the judge said. Okay, I say, show me on a transcript somewhere in America where a judge said this is a good book. That's what I want to see. You're not going to see that. They're not going to say that. You know what I'm saying? They're not going to put that in writing because they know that if they say anything in court and it's not on the record, like, for instance, another thing people do. They go into court and say, well, the attorney lied on me. I said, well, was the attorney sworn in? No. Well, he didn't lie. That's called hearsay. You're supposed to object to it. When they start saying, well, Your Honor, Yusef L., he has a radio show called High Frequency where he spews all kind of anti-government propaganda to the listening. Objection, Your Honor, hearsay. If counsel wishes to testify, please have him take the stand and swear in under oath and subject himself to cross-examination. I don't want him talking. I want him to get on the stand since he wants to testify. Then get on this, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And then you can start talking all of that. I'll give you all an example. Like, I was in a court case, and this probably cost me everything in life. It's when I had my first criminal case, and, they said I had a gun. In feds, they give you a gun enhancement. And gun enhancement can equal like 2 extra years in prison. They won't give you a gun charge. That's why I first learned about gun enhancements. Like, you can get a gun charge, get 5 or 10 years, but they got gun enhancements that'll give you like 2 years or something like that. So, I'm like, I bought and paid for my guns. My guns, I got them from, gun shows. I had an AK-47 with a 75 round Tommy gun clip. I had about, 4 pistol grip pumps. I had AR-15. I had a snub nose 357 Magnum, a 45 Glock 45, and I bought my wife what I bought my wife? I bought her a P9 9mm, and she was deadly with it too. So nigga break in here, blow his ass away. I have a house full of killers. But anyway, I had all these guns. So, I was asking them, they came to arrest me. They came like 20 deep with, ATF and everything. I'm like, why y'all bring all these people to my house? And he's breaking down how many guns. I said, well, I bought the guns. I ain't robbed nobody or nothing like that. But this is our reason for coming like this. But anyway, I get in court and they give me a gun enhancement, and I'm kind of like, I'm looking at my pre-sentence investigation report because, they give you your little pre-sentence investigation. And I'm looking at it, and I'm like, and the attorney's in there, they ain't did the little pre-sentence investigation. The attorney ain't told me this bullshit, this enhancement in there. But he looking at, he watching me read it. He trying to hope I don't catch the shit, because I read everything, especially when my life is on the line. I read every word of that shit. So I'm reading it. So I get to this enhancement. It's like 2-3 point enhancement or something like that. I'm looking at it. I just say, man, what's this right here, man? What is this right here? Oh, somebody said you pulled a gun on somebody. I said, somebody said I pulled a gun on somebody. I said, do you got a gun? They don't even have a gun. They ain't found my guns or nothing. They ain't got the gun or nothing. I'm like, okay, so you didn't catch me with no gun. You don't have no gun. I ain't got no stolen guns or nothing. It's my right, because I didn't have no felonies at this time, so it's my right as an American citizen to have a gun and everything, but you still going to give me an enhancement. This is how the government gets down on you. They do stuff like this when you don't agree to cooperate. Now, I didn't have no Rule 35 and none of that shit. So all y'all niggas out there listening and everything, y'all in there giving substantial assistance to the government, you know what the fuck I'm talking about, okay? You go fuck up somebody else's life because your ass wasn't hustling the correct way. But anyway, so the thing is like I'm asking him, I'm like, what is this right here? You know what I'm saying? He's like, oh, well, somebody said you pulled a gun on somebody. I'm like, so, I'm trying to say, well, man, that's hearsay, ain't it? He said, well, a hearsay is admissible. And I'm like, what? I said, and then I asked him, I asked the attorney, I said, well, man, what about my constitutional rights? This is what I told the attorney. Now, we were standing outside the federal building when I asked him this question. It was late at night, I remember, and everything. And he looked around. When I asked him that question, he looked to his right and looked to his left to make sure nobody was listening to what he was about to say to me. He said to me is the Constitution don't mean shit. That's what he said to me. So I'm sitting there looking like, oh, shit, I'm like, what? I'm saying, what do you mean, And then I go into court, and the prosecutor, they got me in sentencing. At sentencing, you can object to anything that was in the pre-sentence when they're about to sentence you. And that's when you can argue things that are in the pre-sentence investigation report. So, the attorney sitting next to me and everything, and, the prosecutor saying, well, Your Honor, he has a gun, and well, the judge said, well, who said he had a gun? And, then finally I knew who the confidential informant was because, the judge made her say his name in open court, and he wasn't even in court. So I'm hitting the attorney, and then she said something else. She said I had a stolen car, and what was real funny, that the car she said I stole, which I hadn't had a stolen car, I drove up to the courthouse. So she's saying I stole a car. The car she's describing that I stole was in the parking lot in the federal building. I drove it up to the courthouse. So I'm sitting there. This is the type of shit they do now. Because I'm sitting, this is before I knew anything. So I'm sitting there looking, and I'm like, I'm hitting the attorney up. I'm hitting him. I said, man, the car's parked. What the fuck is she talking about? Man, the car's parked outside. Say something. This motherfucker looked at me, and he looked like death had walked over his grave. And he didn't say shit. And a lot of y'all know what I'm talking about. The prosecutor and the defense attorney looking scared and shit. And then later on, I found out that because he didn't object, everything that attorney said stuck. If you don't object to it, it becomes a fact. Hearsay is admissible if it is not objected to. And I had to find all of this out by studying administrative law. I couldn't, for years that bothered me because, I ended up like staying extra 2 years in prison, and I lost my family and a whole bunch of other stuff. And a lot of time that bothered me, because it was like the difference between 5 years and a year and a half in jail or something like that, 2 years in jail or something. And I was like, it just bothered me for years. I couldn't, it was just eating at me because I was like, man, how could somebody convict me of something or add some type of charge to me that I was completely innocent of? You know what I'm saying? I'm willing to accept, anything that I've done, responsibility for what I've done. But, it just seemed to me like, it was an injustice. And I knew why they did it. They did it to me because, I refused to assist them. It's like they wanted me to help them, and, I refused to do so. And, and this is how they do. They start retaliating. They start charging your wife, and it's just heads up for everybody. If you're not going to help the government, the next thing they start looking to do is seeing if they can put some charges on some of your loved ones. If you're married to somebody who's out there hustling or something like that, whether you're at home, because a lot of hustlers keep their girls safe, you just stay at home and spend the money and have the babies and shit. And but they'll try to bring your ass in or something like that. In my situation, it was money laundering. They said, well, your wife, we're going to charge her with money laundering. I'm like, what the fuck is you talking about, man? My wife stay home and take care of the kids. Well, somebody told us that you wired Western Union $2,000 to her. This type of ridiculous shit they do. So I'm like, I said, what? Wired? I said, what? Somebody told you that? And he said, yeah, somebody said it. And so they told me, they said, well, look, your wife may be innocent of all of this, but we're going to charge her. She's going to have to get an attorney. She's going to have to post bail. Do you really want to take her through all of that? This is the type of shit that they do. The feds is listening. They listening to the show. They always listen to the show, so they know what type of pieces of shit they are. But y'all need to kind of be aware of the type of bullshit they do too. They'll say something like, well, yeah, you probably didn't do it, but we're giving you charges for all the shit that we didn't catch you doing. This is the type of shit they will say. They give you extra charges because they know it's a lot of shit you did that they didn't catch you doing, so they give you those charges anyway to take care of all the shit they didn't catch you doing. This is the type of shit they're doing. Now, if you go to trial with these people, okay, all right, whatever they say they're going to give you, you're going to get it, okay? If you're going to do a deal and they say they're going to give you 7 years, all right, but if you go to trial, you're going to get 15. You're going to get 15 years, okay? You're going to get that. They're going to give you 15 years. They're not playing. They're not playing with you, or anything like that. You're going to get that time, okay? So I don't suggest anybody go to trial in the feds. Okay, because when you go to trial in the feds, you're going to be spending the rest of your life or some years of your life in prison regretting that you did not take that deal. So if everything else fails, go ahead and take the deal or whatever, you know what I'm saying? Because, if you go to trial or something like that, you're going to lose because, first of all, you're not in a real court of law. You're in an administrative hearing. And an administrative hearing, what that means is you're being looked at even though you don't think that your property. Everybody who's a U.S. citizen is essentially property. Okay, so you're not afforded the same rights as you would be as you as a private citizen of the republic, or you had your status correct. Okay, so first of all, off the rip, you're a U.S. citizen. Let me show y'all something. There was somebody who had they were in the form. I want y'all to pay it. This is what you got to look at. Things that they say, little things that they say. Because they try to act like you don't have no right to change your status. This is another thing that they kind of give you the impression that you don't have a right to change your status. And I found this very, very interesting. Very, very interesting. Very interesting. Okay. This is the FBI. And listen to this. This is something they'll say. This is the FBI. This is on the FBI. Now, I'm on the FBI website. This is Federal Bureau of Investigation. Prison man convicted for mailing fictitious financial instruments. Because somebody was, they're always on my website. Somebody trying to say, well, I sent off. Somebody said they did the Ajamo Bay process and for 90 days and it didn't come off. And I said, nigga, how did you follow the Ajamo Bay process and the webinar wasn't even 90 days ago? It was like 45 days ago. They be lying and shit, coming into the chat room trying to, trying to make somebody's process look like it doesn't work and, shit like that. But anyway, I'm looking at this and I'm saying, this is the Fed. Somebody posted this. And I said, well, did you read this? It says, Florence, a federal jury late Tuesday convicted a Penson man and member of an anti-government sovereign citizen group for mailing a fictitious financial instrument to pay off his home mortgage, announced U.S. Attorney Joyce White Vance and FBI Special Agent in charge Richard D. Schwein, Jr. So instantly everybody will say, I told you them people sending in those negotiable instruments and everything, they get arrested. I said, well, did you see what the negotiable instrument looked like that they sent in? No. So you don't know what they put on the instrument that caused them to want to arrest him. But I don't need to see it because basically the feds will tell you, basically. So let's continue. It says, the jury convicted Donald Joe Barber, 64, of mailing a fictitious bonded promissory note to his mortgage servicing company on March 10, 2008, in a fraudulent effort to satisfy his mortgage. Barber presented the fraudulent $10 million note as if it were a valid financial instrument drawn on a secret U.S. government account. So the key word here is drawn on a secret account. Every time you see somebody get arrested, that's what it's going to be. You're trying to do a draw on a secret U.S. government account. U.S. District Judge Inga P. Johnson scheduled Barber's sentencing for July 31st. Now, look at what this government agent said right here. Now, pay attention to what he said. Self-appointed sovereign citizens preach an extremist anti-government ideology to their followers and teach a myth about American history that is untrue, Vance said. Okay, now, what exactly are we saying that is untrue? I'd like you to kind of like go into that. And I've never heard the word sovereign citizen. I can't find it in a law dictionary anywhere. And it's not anti-government. There's a public law and a private law. Anybody can get any Black's Law Dictionary or go on Wikipedia or whatever and look up the word public law, and you'll see public law is government and private law is absence of government. So if I'm doing everything privately, you don't have any fucking thing to do with it. I don't care what the fuck type of propaganda you're talking about or you're spewing on your websites because you are ignorant. All right? You're very, very ignorant, or you are trying to mislead people into thinking that they don't have any private rights or right to privacy, and you know that they do. All right? Now, listen to what this agent said. He says, they often use this mythical ideology to justify crime. Okay? What crime are you talking about? Who's committing a crime? Okay, this is also the reason, y'all, why we do a secure party process where before you send them a promissory note or anything, your entire first package don't have no negotiable instruments in it, no bonds, no nothing. It is a notice of your status, of your intentions, and what you're going to do. You're sending it to the Treasury Department, and you're giving them 30 days to respond to you before you send them anything. All right? You're letting them know. You're letting them know what promissory notes you're going to be using, international bill of exchange, what you're going to be using, what they're going to be used for, everything. And if they got something to say about it, they are afforded an opportunity to say something about it at that time. As well as the fact that you need to put together a negotiable instrument. If you just put void where prohibited by law on your instruments, that would kill all of this. Void where prohibited by law. If this is illegal, if you deem this to be illegal, then the document is void. It goes on. It says, they often use the mythical ideology to justify crime. Sovereign citizens may disavow the authority of the U.S. government, but it exists, and my office will use it to prosecute those who break the law, she said. All right. Now, nobody's disavowing, for all the federal agents that are out there, nobody's disavowing the federal government. You as well. Now, most of you federal FBI agents, y'all are attorneys. I don't know if people know that. A lot of them have like law degrees and things of that nature. You understand that everything is jurisdiction. You know you have a jurisdiction. All right? You have a jurisdiction. Law speak. Okay? That your authority is delegated to you by the Constitution for the United States of America. Okay? We have an Article 1, Article 2, and Article 3 branches of federal government. Okay? And under Article 1, Section 8, okay, that is where the legislature gets their powers. Okay? Now, you are an agency of government, and you get a delegation of a power from Congress to go out and enforce these United States Code statutes. Okay, you can't enforce any powers that were not delegated to any of the senators or the House of Representatives on Capitol Hill. All right, so let's not play games, okay? You are assuming that most people don't read the Constitution or they don't understand separation of powers doctrine or as well as delegation of powers doctrine. You're assuming that. But some of us do understand that, and we can, have a conversation. We're very conversant about how the government is set up. As a matter of fact, it is the duty of every American citizen to understand the powers that have been delegated to the agents of the federal government. It's your duty to understand that. That's something that should be taught in elementary school. And that is something else I would like to say to all the federal agents out there. Why why aren't y'all teaching that to like young people? If you're so concerned about people breaking the law, I mean, why aren't you educating people like why isn't part of the curriculum in public school for you to understand how the government is set up, what it means to do the Pledge of Allegiance and all that stuff? Why aren't y'all like make that a part of the curriculum? Why is it that, our educational system is amongst the worst on planet Earth? Right? It goes on, it says, the guilty verdict handed down in this case should serve as a deterrent to others who claim to be sovereign citizens. Well, I don't think anybody on high-frequency radio is going to claim to be an oxymoron because, once again, I've never seen this word sovereign citizen. However, I can pull a plethora of citations of authority that will demonstrate that the people of the United States of America are sovereign. The sovereignty rests with the people, not in government. I think y'all know that, though. That's why you use the word sovereign citizen. An attempt to use a redemption scheme to fail to pay just debts. Now, what are just debts? Yeah, I don't understand. What's a just debt? In America, we don't have just debts. We only have presumption of debt. There's always a presumption of a debt. Okay, I think every attorney understands that. There's only a presumption of a debt until it's been agreed to, in fact, or someone has proven that there is a debt. This is why we have a Fair Debt Collection Practices Act. So I don't know what a just debt means. I'm kind of hazy on that. What is a just when the United States on public record is in bankruptcy? House Joint Resolution 192, June 5th, 1933, Public Law 73-10. And we can go to Title 31-5118D2 and we can find out where that has been codified at. I'm not understanding what you're talking about right there. It says the guilty verdict. Okay, wait a minute, I'm going to say the FBI describes members of the sovereign citizen movement in the U.S. as U.S. citizens who openly reject their citizenship status and claim to exist beyond the realm of government and authority. Okay, so now this was a weird sentence because you're describing us as, yes, we're trying to get rid of our U.S. citizenship. We're trying to get rid of that. We're trying. Are you saying we don't have a God-given right to get away from y'all crazy ass when you see that you lock up more people than any other country on planet Earth, that you have draconian laws? President Obama just said this. Did y'all hear the President Obama speech? Let me see if I can load that for y'all. I want y'all to listen to this speech to President Obama. President Obama, he made a very, very beautiful speech on prison reform. And he visited that's right here. I'm going to put it in the chat room. Y'all can listen to it. It was at a double NAACP conference. Y'all should check it out. It was real good. Where he was talking about, prison reform and everything. He's talking about, how, the unfairness of the prison system. But it was a very good speech. I mean, that was the best speech I ever heard Obama make, man. I mean, he's the first sitting president to ever visit a prison. None of your presidents have ever visited a prison. He visited the El Reno Federal Correctional Institution, President Obama. And then they videotaped it. He's in the prison. Here, let me put it right there. He came into the prison. I got to give the man his props, And he talked about the sentencing guidelines, which, every federal agent out there, y'all know that if we have separation of powers and you have an Article 3 judge, that's what separation of powers means, that one branch of government can't direct another branch of government what to do. So how do we have sentencing guidelines? Please explain to me. You don't have to. I understand it. That's an Article 1 court. Congress can give guidelines for judges in their courts. All right? It's a territorial court. You're in the United States, and you're trying to give everybody the impression that the United States means the entire continent, North American continent, and you know as well as I do that the United States is in Washington, D.C. It didn't pull up. But I forgot I think it's 929 dash. I forgot. Anybody in the chat know what that UCC is? Where it says the United States is in Washington, D.C. I mean, it's a real good one. It's in the UCC. It tells you where United States is. It's in Washington, D.C. And that's that is the misconception. I'll get it later. I'll give it to y'all later. That's the misconception that, they're foisting on everybody. They're giving everybody the impression that, that they're really, that the country, this is what the feds are doing. They want all of y'all to think that United States means all of America. United States means any type of territory of the United States, which is a corporation. It does not mean the entire continent, North American continent. You have jurisdiction over certain things, and you know that. And one of the things that you have is that you regulate commerce. I understand that. I don't have a problem with that. Nobody's mad at you, for y'all regulating your property. The only thing we're mad about is that you are trying to, fool people into thinking that they don't have any options. You're trying to make yourself seem like y'all on the same level as God or something like that, that you're the supreme authority or something like that. And it's in all of your correspondence. It's just deceptive. You're very skillful at writing your correspondence in a way that it always gives people the impression that you're talking about the entire country. When you use the word U.S., and why don't you say USA citizen, United States of America? Why is it always U.S. citizen? Why can't it be United States of America citizen? Why does that to be a U.S. citizen? I thought it was the United States of America. Well, I thought it was USA. Why is it U.S.? Why is it United States District Court? Why ain't it the United States of America District Court? Why y'all just put U.S. Court on all the buildings and everything? Why just add just simple questions that y'all could ask them. Just ask them. You know what I'm saying? Why is that? Why y'all say United States? Put United States on everything. United States, United States, United States. But anyway, right now, I'm going to read this to you, this letter of rogatory, because I kind of digress. But I kind of want y'all to kind of see right here. They say, calling us U.S. citizens openly reject their citizenship status and claim to exist beyond the realm of government authority. Let me ask you a question. Is there a realm, ask a federal agent is there a realm that exists beyond government authority? And if so, how can I access it? They'll probably tell you that you have to leave the country. And just ask them, is there because any judge, I already know y'all don't have authority, because everybody we had federal cases where judges dismissed cases for lack of jurisdiction. I mean, so that right there lets you know that y'all don't have some authority and everything, because the judges have thrown thousands of cases out of the court. They said, well, we don't have jurisdiction on it. We have to have diversity of jurisdiction or something, but we don't have jurisdiction over this. So we know that there exists, but ask them that. I said, well, is there some sort of realm or something that is beyond your authority? Or are y'all like God or something like that? You're all powerful, infallible, whatever. You can do whatever you want to do. Is that the impression that you're trying to give everybody, that the federal government can do whatever you want to do? That is the reason why we have gun rights. Because when that thinking process starts to spring up, the purpose of having guns was to shoot everybody in government who thinks like that. That was the purpose of having guns. That's why in America, all the citizens have guns. They were supposed to shoot agents and people who think they have power, ultimate power and authority over everybody. You're supposed to shoot those people. I don't mind saying it, and I'm not saying anything wrong, because they know that is the original purpose of gun rights. It was to secure, so we didn't have whatever happened in England, in this country. You wouldn't have that, because the power is in the people in this country. This is not a monarchy, an oligarchy, or anything like that. The power is in the people. So here in this country, if government agents get out of hand, we have the authority to shoot their ass, okay? That's, that might sound kind of harsh or anti-government, but it's just the truth. And they know it's the truth. The truth of the matter is, y'all don't have authority to do whatever you want to do. You're supposed to be, you're beholding to the people. So, so I don't understand what you're saying. If you're beholding to the people, what is it that you're saying that, we can't change our status if we want? We can't, not want to participate. We can't go private and not participate. And I do understand that it is incumbent upon us to understand what your jurisdiction is, and that's what I try to do on this show. I try to tell people, look, the government is not wrong at what they're doing. We just need to get out of their jurisdiction, and that's what we're attempting to do. You know, but I know the government, y'all don't like that because then you can't tax people and everything is about taxes. But we don't need big government. We need a small government. We don't need you in everybody's business. We need to rescind. We really need to get rid of House Joint Resolution 192 of June 5th, 1933, because it created what was called a welfare state. And everybody out there has a welfare state of mind right now, which is really the underlying problem of all the problems that we're having, is everybody thinks, you know, we're welfare recipients, basically. But anyway, let's get back to what we were talking about. We're talking about public defenders, and we're talking about letters of rogatory. And I was reading a letter. It was on my website. It's using the attorney for protection of private rights. It's in the PDF section of my website. And when you go down to the PDF section, under commercial, you'll see using the attorney for private rights. And I'm going to read this to you. Oh, and real quick, let me make a quick announcement. In case you did not know, it is Labor Day, and I'm having a Labor Day sale on the webinars. All webinars are 50% off. Everything in the store. And it ends midnight tonight. Please do not call me and say, Yusef, man, I missed the sale, man. Can you kind of like, hook a brother up, man, and let me get that webinar for that. Now, I'm telling you right now, it's 50% off. I mean, we got webinars in there for $12.50. Okay, so please don't bitch to me about the cost of stuff or anything like that. I mean, I'm doing, just, you know what I'm saying? It's like, wow. But it's 50% off. So take advantage of that today. All right? Only till midnight tonight. So if there was something back there you seen that you wanted, go ahead and grab it. But anyway, let's get back to, I'm going to read this. This is a letter. It's 4 pages. I'm going to read the whole thing to you. It says, using the attorney as a private lawyer under private international law. Now, this guy, he's a little religious, and I'm okay with that because religion does play a part in this, because in being private, you have to respect and honor the creator of the boundless universe. That is incumbent upon you to understand that and to start studying the principles of nature. All right? It's very, very important because that's where you find God. You find God evidenced in nature. You find God evidenced in life. It says, I've been studying law for about 30 years as a hobby. I used to believe, as many so-called patriots have, that the government and attorneys and judges are doing things wrong and violating the law and the Constitution. How ignorant I was. I was like the people of Jerusalem when the prophets were telling the people and the king of Jerusalem that Yahweh loved the people of Judah who were slaves to the king of Babylon better than Yahweh loved the people of Jerusalem who were fighting against the king of Babylon. The old way of believing that the patriots of Jerusalem were more loved by Yahweh than the slaves of Babylon was before I got a clue and understood the prophets. I was a child mind. Now I believe that Yahweh in heaven is bringing my mind more in line as a man. And you know what? I've been guilty of that. I kind of look at the government as like demons, you know what I'm saying? And look us as the godly people, when we know that that's not true, because the people, they do no evil shit than anybody can even think of. Ain't nothing morally. You look at our society, ain't nobody doing anything morally upright. But, that's just not true. The government, they are the protectors of the realm of God. I want you, you should probably start thinking of it like that, But let's go on. It says, everything is backwards in the public sector because of the financial reorganization that has been ongoing since the beginning of America as a nation. The public world, this world, not the private world, the world, is operating just like the scripture states in 1 Corinthians 13, 9 through 12. It says, the reason is that we are losing the gifts of prophecy, speaking different languages and knowledge. This means that our ability to prophesy are not perfect. But when perfection comes, which is the understanding of what is love, is this what motivates you? The things that are not perfect, which are reasonable, comprehensible, and easily understood in terms of logic, will end. When I was a child, I talked like a child. I thought like a child. I refused to grow up intellectually and smell the roses. When I became a man, I learned what is love and practiced it with my fellow man. I stopped those childish ways, believing God's agents are wrong. It is the same with us. Now we see a dim reflection as if we were looking into a mirror, an unclear vision that is backwards. Right is left and left is right. But then we shall see clearly. Now I know only a part, but then I will fully know as God has known me. In this pattern, I want to share something with you for those with vision. Government, attorneys, and judges are not your enemy. You are your own worst enemy because you do not understand the law, which is the commands of Yahweh. A number of people I'm working with have been offered an attorney by the courts in which the straw men of the people have been charged with criminal charges. Now understand, there are Supreme Court rulings that people cannot be put into prison for the crimes of the straw man if the people have not been offered legal counsel at criminal proceedings. Therefore, judges almost always offer the charged entity the assistance of legal counsel from a licensed attorney if there is a chance of one of the people being jailed after the conviction of the straw man. Since the government and the public are in a financial reorganization, the public and the government have no commercial energy to execute on any criminal charges. They can make no claim. However, they do have powers in admiralty/maritime equity. These powers come from the consent of the governed. This means the people standing behind the charged straw man. These execution powers in equity come from the acts of contempt by people who do not give honor to the public in governmental proceedings. Everyone who goes to jail on sentence is there of his own permission, which comes from contempt or dishonor. When the court offers one of the services of an attorney, this offer is a commercial draft. The court is the drawer, which is the debtor. The offeree, the patriot, is the creditor or the drawee. He is the banker, which can honor the court by acceptance. To accept the offer is to go into dishonor. And I had an attorney tell me this, and he said, you haven't accepted the charge. I mean, this attorney knew that I knew. He would come and visit me. He would tell me, you haven't accepted the charges. You haven't accepted the charges. Remember, you're the principal. You tell me that. He says, to go into dishonor is a contempt. This makes the patriot a debtor to the court, which empowers the court by voluntary consent to carry out the execution of a charge that is not supported by the rules of evidence as if it were a common law conviction. The prison sentence is for contempt of court by dishonor. The length of the sentence is the sentence for the crime if the public and the government, under their disability of reorganization, would have the power of common law execution, which they do not, except that you give it to them by your dishonor. Because of the above process, many wise patriots whose straw men are charged in the public courts not accept the offer of the public attorney or defender. This creates an honorable relationship between the people and the government, judges and attorneys. It also makes the patriot the creditor in the situation, if the patriot knows how to act as a creditor. One who has been offered an attorney must accept the offer by written contract. The contract is nothing more than a copy of the written order with an acceptance for value and return for value written across it with the patriot's signature and the EIN or the exemption identification number written on it with the date. The original signed and merged agreement is placed back into the clerk's file of the proceeding as evidence. There is now an agreement in fact, and it appears to the public side of the proceeding. After the agreement in fact is established, the patriot, being the creditor of the agreement, has the capacity to draft the appointed attorney to carry out whatever honorable functions the patriot has for the attorney to address the substance and the procedure of the charges. This can be done by the use of a letter rogatory. A letter rogatory is a private letter from the clerk or official of one court to the clerk or official of another court. Its purpose is to direct the second court to take evidence or testimony to resolve some issue between the two jurisdictions. Get the picture. The government and the judges, attorneys, prosecutors, etc., are members of a foreign government with its foreign court. Their government operates a commercial corporation for profit and gain to make a revenue off of persons by confusing people. It is not the government established under the so-called authority of the people. It has morphed into a foreign military democracy of fictitious persons that is reorganized commercially, bankrupt if it were an individual. As such, the officials in the courts of this foreign government are basically like military officials operating a private civilian front organization to conceal its true nature. any military court, there are no entities permitted to practice therein who are not military officers. The judges, prosecutors, attorneys, and other persons in the court are all elected or appointed officials of that quasi-military organization and officers of that foreign court. If you are not an officer, you cannot practice in that foreign court. Why do you as a patriot want to go in there and help officiate in that foreign court? You have no standing. If you do go in there, you have given jurisdiction by impersonating a military official of that foreign tribunal, and you are not in Kansas anymore, Dorothy. So, in order to help officiate the charges against the fictitious straw man in their foreign court, you, as a living soul, write a letter of rogatory to the officers of that court to help them officiate the issue. The letter specifically gives assistance to the appointed attorney so he can help them resolve the created dilemma. A letter, such as the following example, establishes duties for the appointed attorney pursuant to your request. Note that the charged entity is a fiction and cannot do anything in his own defense. Also note that the straw man was created by that foreign military venue as their vessel of commerce. You did not create her. They are just testing you. Remember in the movie The Recruit? Al Pacino's character, who worked for the CIA, stated that everything is a test. Even when you think it's not a test, everything is a test. If you screw up, you are in dishonor and failed the test and go straight to execution or punishment for your dishonor. The foreign court operates under presumptions, assumptions, and conclusions, as do all equity courts. They assume and presume that the living soul is operating the straw man they created for co-business profit and gain in the world commercial markets. If this is true, then the living soul immediately comes under the jurisdiction and venue of these equity courts for their assumed co-business ventures with a person, the straw man, created by their foreign government. It does you no good to argue jurisdiction or venue. What part of no jurisdiction or venue applies to their straw man and your assumed and presumed commercial actions associated with it? The living soul is not a corporation. The living soul has rights, duties, and remedies that can be brought to the foreign court by appropriate procedures. This must be through one of their officers, the attorney, the public defender. If you accept the appointment for value and establish the agreement in fact in the court record, then the letter of rogatory is the way to draft this officer to make the appropriate evidence and procedures visible to the foreign court so that the charges can be accepted and discharged for closure and settlement. Now, he's going to give an example of a letter of rogatory, and I'm going to run through this. Okay? Now, when I do letters of rogatory, I always use the caption of the pleading of whatever court I'm in, okay? In other words, if you don't know what a caption of a pleading is, that's at the top of court documents where it says United States versus whoever else and has your case number at the top. That very top part of that document is called a caption of a pleading, okay? So you need to understand, in every jurisdiction, they arrange the caption of pleadings differently. Even in some jurisdictions, the judges will have a preference on what type of font you're supposed to use and the font size. So if you want to do some investigation, you may want to go into your rules of court and look all that up too as well. You want to see, okay, because judges are that particular. Some of them want 14-point font because they can't see, they can't read. Some of them want double spacing, okay? They want almost all courts want double spacing. Sometimes it's space 1.5 spacing. You need to check and see in your jurisdiction. You need to find what the rules of court are so you can start constructing your documents so at least they're in conformity and that they are aesthetically acceptable to whatever court that you are operating in. This at least demonstrates some consideration that you are making an effort to go out and find out, the proper way of doing things. Now, so what I will do is I'll put the caption of the pleading on here. Now, any letter that I write to my attorney, I also do the same thing because a lot of people, they always want to use the defense insufficient counsel. You're going to find that this is probably the number one reason people go back to court or attempt to go back to court or file some sort of appeal on the federal level is insufficient counsel because the public defender never does anything for anyone because no one ever gives them any instructions in writing of what they want them to do. That's primarily the thing. So if I'm in jail and I wanted to tell my attorney to do something, I don't get on the phone and call my girl and tell her to talk to him. I write him a letter and I put it on pleading paper, and then I send a copy to the clerk and I send a copy to the attorney. That way, it is on the record. I got in the evidence file of what I've told this attorney to do. Now, I only do this if I'm in jail and if nobody's helping you. Like say nobody's helping you in jail. You don't have anybody on the outside helping you. Well, what you can do is when you write your letters to the attorney, always put it in caption in the pleading so it'll be acceptable to the clerk. She will file it. Now you have in the evidence file what you told him to do. So now when you make any argument about insufficient counsel, at least you'll have a leg to stand on, because now you get the evidence in the evidence file of what you have been sending to this man or woman and what instructions that you gave to them and that they did not follow your instructions properly. So here we have a letter of rogatory, which is an acceptance of counsel and request for service in case number blah, blah, blah. Now, dear sir, okay, please be advised that I humbly accept your appointment as per the court appointment in the state of Michigan or in the United States District Court case number, whatever. Okay, now I request that you perform the following on behalf of the undersigned. Now, here are the instructions that you're going to give to your attorney. There's going to be a lot of similarities. I'm going to show you, this is one letter of rogatory, and I'm going to show you one more after this. I'm going to give you two different examples of instructions that you give to public defenders. Now, number one, I do not argue any facts on the public side of the above matter on behalf of the undersigned. The wed-pled facts are all true therein and not disputed. To dispute the facts takes away my ability to dispute the substance of presumption in fact. Now, a lot of people, if you do not understand what this is saying, the reason you want to argue, you do not want to argue any facts. Well, first of all, I have to go back to the Bible, because in the spirit of Matthew 5:25, it tells you to agree with your adversary before you get to court. Now, if you're a Christian man or woman, you should be following what Jesus said, because that's what Jesus told you to do. Jesus told you don't go in there and go and argue with these motherfuckers, all right? Reach some type of agreement before you get in there. Before you go. Get your agreements before you go. They're always trying to do it. When the prosecutor offers you a deal, that's him trying to reach an agreement with you before he gets to court. He's following God's law. Hey, look, I'm going to give you, instead of, just go ahead and plead out, I'll give you, 15 years and 10 years probation. But he is attempting to reach an agreement with you, because if he's offering you 15 years, he's thinking about giving you 30. Because he wants you, if you go in there and argue, he's going to try to give you 25 or 30. Okay, this is what's happening, okay? So he's trying to reach an agreement with you. Now, this is where your spirituality comes into play, because it takes a very strong person spiritually, for somebody to come to you and say, well, we're offering you 15 years, take this deal or go to trial. It takes a very strong person spiritually, and I respect anybody in federal prison who went to trial. It took a lot of guts and gumption to do that. And some of y'all are winning and getting your time reduced on appeal and things like that. It takes a lot of guts to do that. It takes a lot of guts to do that, to go to trial and everything. So you have to be a very strong person spiritually to do that. But we can enhance that attitude with the proper knowledge, of what's going on. And the first thing that we have to understand is you're not in a court of law. You're in a territorial court. And they're practicing administrative law against you, because it's an administrative agency that is bringing you into court. All right? Now, before I continue and read this letter of rogatory, I want to direct everybody's attention also on my website, highfrequencyradionetwork.com, under the PDF section, under the constitutional section, we have something called Outline of the Constitution. This is a document that I created because I wanted people to understand how the government is set up and how everything comes under Article 1. And how these courts are operating. And all these definitions come straight out of Black's Law Dictionary. This is nothing on that document is something that I wrote. Everything comes out of Black's Law Dictionary. And you'll see there, it talks about Congress also has the power within certain limits to create what are called Article 1 tribunals. These Article 1 tribunals are really akin to administrative agencies. So right here in the Black's Law Dictionary, they're telling you what they are. They're not really courts. You're going into an administrative agency. This is the reason why you don't get to see the judge so often. And when you do see him, you're there only to plead or do something like that. And if you go to trial, it's really a dog and pony show, because you're not really in a court of law. You're an administrative agency. You're being looked at. This is how you know that U.S. citizens are slaves. Now, they do the same thing when you go into prison. When you go into prison, in federal prison, they'll give you what's called a shot. Okay, once you get a shot, they bring you before an administrative tribunal. There'll be 3 people in there. Okay, they will ask you, do you want representation? It could be your counselor. It could be anybody like that. And then they will go over, and almost all the time they will find you guilty, and either they'll put you in the hole, they'll transfer you, or give you some sort of duty, clean up, or something like that. Now, if you pay attention and you're very astute, this is only for my people who've been to federal prison, you will notice that they're using the very same procedure when you get a shot as they do when they sentence you to prison. It's the same thing. It is the exact same procedures because they're using administrative law. It's administrative agencies, and that's the law that they follow. So really, when you go into court, when you catch a federal charge, it's like you are already convicted. It's the same thing. You're going before like your masters. You know, like the prison officials. You being a U.S. citizen is like you're in a prison. So you're being brought before the board of the prison officials, and they say, oh, your conduct, look what you was doing out there. Oh, we're going to have to sanction you or give you a shot, you know, and we're going to put you in the prison. We're going to put you into slavery. We're going, you know, you already was a slave walking around. Now we're going to restrict your liberties even more and put you in a box or a cage where you can't walk around. And this is what's going on, and this is why it's so important for people to understand that slavery is alive and well, so you can understand what real freedom is. This is why I'm doing these shows and everything, because y'all have a misconception of freedom, all right? When you go into prison, you'll start to get a reality check and see what is really going on in this country. People are not free, not like you think you are, at least, okay? And I'm no man's slave. I don't know about you. Some of you may be content with your jobs and, you know, and things like that, and being able to go to school and do all those things. You may be content with that. But just with me, the very idea that another man on planet Earth considers me to be his slave is something I cannot live with. He says, give me liberty or give me death. You have to let these people know I'd rather die before I be your slave. Anyway, let's go back to this letter of rogatory. This is a letter of instruction to an attorney. And the first thing you're going to ask him is not to argue any facts, because if you argue facts, that's going to make you have a jury trial. Okay? If you do not want to go to trial, don't argue facts. If you do not want to go to trial, don't argue facts. Trial is for fact-finding. Let me see if I can find this for you. Let's look up the word fact-finding. Let's look up fact-finding. 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 I'm coming out of a Black's Law 8th edition. Look, they got fact. They got material fact. Look at all these different facts. When you look up the word fact, look at all these facts. Fact and issue. Okay, fact and issue. A fact and issue is a fact as to the correctness of which the tribunal, under the law of the case, must be persuaded. The term probandum, thing to be proved, will here be used as a convenient single word. And fact in pays, ancient fact, in pays is, I think, outside of court, in pays. Let me see, material fact, immaterial fact, the fact that is not relevant to the matter in issue. Operative fact, they got a whole bunch of facts in here. Let's see, fact finding. Let's see, Thomas M. Line, procedure, due process, and human rights fact finding. Fact finding board. They got a word called, okay, fact finding. Here it is. It's on page 1778 in the Black's Law 8th edition. Fact finding. The process of taking evidence to determine the truth about a disputed point of fact. Okay, disputed. Okay, fact finding must be as impartial and as fair to the parties as procedural and evidentiary rules can render it without making the inquiry's task impossible, not merely for ethical reasons, but in order to maximize the credibility and impact of the facts found. To this end, fact finders must develop procedures that sharply distinguish them from those bodies that assemble prosecutorial evidence. Okay? Now let's see if we can find fact finders. Fact finder. One or more persons, such as jurors in a trial or administrative law judges in a hearing, who hear testimony and review evidence to rule on a factual issue. Page 1778. So you're going in front of a fact finder. Is a jury or a administrative law judge? I'm just saying we're going into administrative court. So if you are arguing anything, you're going to go in front of a jury, which is a jury trial, or an administrative law judge, which is a bench trial. So the first thing you don't want to do is argue. Okay? You always tell them there is no argument. If you argue anything, they have to go to fact finding before a fact finder. A fact finder is a jury trial or an administrative, and we already know that when they're enforcing, you already know that when a judge is enforcing a statute, he's acting as an administrator. Here it is. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts, in administering or enforcing statutes, do not act judicially, but merely ministerially. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. The agency has already made a determination. It's these agencies. You're under these agents. That's why in the Matrix, Neo was going against agents. They were trying to tell y'all something in that movie. It's these agents out here. All right, you're under administrative law. You're not under real law, a real body of law. You're looked at as some kind of property. And the reason for that is because they are administering a bankruptcy and their jurisdiction is purely commercial in nature. And you're being deemed to be some sort of merchant operating in commerce. And within that jurisdiction, you don't have certain rights. You don't have access to the full gamut of all your inalienable rights that are granted to you by the creator of the balanced universe. So the first thing we don't want to do is we don't want to argue. I'm reading from Using the Private Attorney for Private International Law. It's on my website. So let's keep going. Number 2, represent the undersigned only on the private side of the matter as per my directions herein and any subsequent directions. Okay, you're letting your public defender know that, hey, I'm going to be doing things privately. Okay, I want you to follow my private directions. All right, so next, secure for the undersigned a personal appearance bond or personal recognizance bond without public charge and without public fees or cost, so that I can plead to the charging instrument as my remedy in this matter in law, not equity. Now, here we go. A lot of y'all call it, on the street, y'all use the colloquialism, a signature bond. But what it really is a recognizance bond. And a recognizance bond is it's almost like you pleading guilty to the facts. You're agreeing. But another way of saying recognizance bond is a bond at no cost. Give me appearance bond at no cost. That's what it is. It is not a catch-all bond. When they bond you out of jail, they're just trying to secure your appearance. All right? It's not a catch-all bond. So an appearance bond at no cost. Now, why are we saying with no cost? You're saying at no cost because when they give you a bond with cost, what that means is you got to come in and do piss tests. You got to report to a public defense, some officer or something like that, and that costs you money, costs you time. You have to drive there and all this. That is why it's called with cost. You want a bond without cost. They will know what you're talking about. If you say to an attorney, I want an appearance bond at no cost, they'll say, okay, I'll ask the judge if he can give you a recognizance bond. Let's go number 4. It is my intent to plead guilty to the facts in the charging instrument and not to controvert any of the well-pled facts therein, which are all true. We're agreeing with our adversary while we're on the way to court. We're not going to argue any facts. The facts don't matter. It is those codes that we have a problem with. All right? We don't have a problem with the facts. So what? Yeah, I wrote a promissory note. So what? How is that illegal? Well, it violates our United States code. Look, I don't have nothing to do with that. I'm not under those codes. I just wrote a piece of paper and signed my damn name to it. Think about this, y'all. Think about this. How can somebody put you in jail for getting a piece of paper, typing some words on it, and signing your name to it, and they feel like they have a right to take your life away and put you in jail for 10 years? That is insanity. If that is not the definition of draconian, I don't know what is. Think about that. You just took a piece of paper. You didn't steal anything from anybody, but you put some words on it and signed your name on it, and somebody want to come and get you and put you in prison. Do you see the insanity in that? Do you see the ridiculousness in that? Do you see that? That's why it could not apply to you. It's impossible. Let's go on. It says, in return, I request that this court discharge the appearance bond to the undersigned at the termination and closure and settlement of this matter. Okay, you want your bond to discharge all the matter. Also request that any and all public or private costs, fees, charges, and restitution that might come out of these courts as any orders in this matter be discharged by exchange of my exemption for settlement and closure, which I hereby authorize under exemption number, and you're going to give your Social Security number without dashes. And that's all they want. They want access to that Social Security trust account, and you need to give them permission. If you don't give them permission to get it, they're going to take it by force. So just give them permission to use it. It says, I request that any and all charging instruments in this matter affecting the undersigned be accepted by you under your signature for and behalf of the undersigned and returned to this court for settlement and closure forthwith. My signature is required on the acceptance. I request that these instruments be delivered to me forthwith for my signature. I request that you direct that these signed and noted instruments be filed on the public side of the court's records. So that would be anything like an indictment. An indictment is a bill of exchange. For instance, like here in Georgia, they have a place for you to sign it, just like a check. It's a check. Okay? And you want to get a certified or authenticated copy of your indictment and right across it, you've accepted it. And give them an authorization to use your exemption to cash it. And if necessary, take one and send it to the IRS. And give one back to the prosecutor. I usually file mine with the clerk. It says, if this court fails to issue an appearance bond to the undersigned under the requested terms of the above paragraph 3, I request that you notify the court publicly of my acceptance of the court's dishonor. And I will presume, based upon that dishonor, that the appearance bond is in fact issued to the undersigned to secure the undersigned's participation in this matter, or that you will direct my own bond to be filed publicly in the record based on the court's dishonor. Now, this is what you do if they dishonor you. Now you get your bond and you read it into the record. Put it on the record because they're dishonoring you. And I did a whole show, Bonding Criminal Cases, where we discussed that. Now, I request that you ask the judge in this matter, it's $12.50 right now. It's $12.50 right now. Bonding Criminal Cases. In case you just joined us, all my webinars are half off for today, one day only. It ends at 12 midnight tonight. It does it automatically. I won't have anything to do with it, but it's going to end at 12 midnight tonight. All webinars are 50% off. Yes, it plays into warrants too. Warrants or checks. You take warrants and you accept those too. You put everything in there. You discharge a warrant. All right? Everything is about, all they're trying to get from you is money. They're trying to get the money. That's it. A warrant is a guarantee that they're going to come and get you and guaranteeing that you're going to pay. They're warranting that they're going to get you and get you to pay something. It goes on, number 9, I request that you ask the judge in this matter in open court if he has a sworn oath of office. And if he answers in the affirmative, I further request that you ask the judge in this matter to publicly take judicial notice of the oath of office of the judge in this matter to provide to me a remedy in law. Okay? Now, they always have to give you a remedy. Attached here, too, is an affidavit of negative averment executed by the undersigned. I request that you forthwith cause this original affidavit to be filed into this court on the public side of the record with the acceptance for value and return for value discussed in paragraph 7, so that the court will have the benefit of the old common law pleading of confession and avoidance. Now, an affidavit of negative averment is basically saying I am in possession of no evidence that would demonstrate that I am a U.S. citizen. I'm in possession of no evidence that would demonstrate that I've broken any law. It's a negative averment. You're asking them to prove everything. Because the onus probandi is on he who asserts, not he who denies. Okay? Now, a confession and avoidance is a common law plea. In the commercial courts, it is equivalent to what is called an acceptance for value or an acceptance for honor. A confession and avoidance is an actual plea. So let's look at confession and avoidance real quick. Let's go back to the Black's Law Dictionary, and let's look up the word confession and avoidance, and let's find out what it is. And I like the word confess and avoid. You can confess to everything they did and avoid the consequences. Don't that kind of sound interesting? It's like, I can agree with everything they said and still get out of it. How is that, Yusef? That sounds crazy. Okay, well, let's look at it. Let's look at it. Because it is in their books. It is in their books. I mean, okay, I'm on page 901, Black's Law, 8th edition, Confession and Avoidance. A plea in which a defendant admits allegations, but, to go to conjunction, but, I like him, but pleads additional facts that deprive the admitted facts of an adverse legal effect. Okay. So you're going to plead additional facts. And what are those additional facts? That you're private, that you are a creditor, that, I'm a secure party, blah, 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 whatever it is that you want to put in there. Now, let's look at number 11. It says, I request this back. Now I'm back reading the instructions to the public defender. I request that you direct the court to take mandatory judicial notice of the instruments tendered for public filing in the court in paragraph 7 and 10 herein, and to enter these filings into evidence at an oral hearing in behalf of the undersigned. Oral hearing, that's how you enter things into evidence. A lot of people think, well, I filed some documents. You entered into evidence by reading it in open court. Read it into the record. I request that you direct the court to take mandatory judicial notice of the documents the state acquired from, and this could be any documents, evidence that the state may have in its possession that provides true facts. That could be your warrant, your indictment, anything, criminal history, all this stuff. And you want to accept those. I do not expect that your kind services be provided without consideration. Please provide me with an invoice so that I may accept and return said invoice for value and direct that the exemption be used as consideration in exchange for these services. This is for the public defender. You want him to get paid. That's another thing. Well, I'm not getting paid for this. Okay, I'm going to pay you. Write me up an invoice. And with that invoice, I'm going to make sure that my exemption, that you get a check. Because y'all monetizing this in the back, so I'm going to put in an authorization for my exemption to make sure you get paid as well. I request that any other services that you perform for the undersigned in this matter be approved by the undersigned before said performance be undertaken. With serious appreciation, John O. And that is a letter of instruction to a public defender. That's one kind. Okay? Now, there's another kind that's in creditors and their bonds, which I'm talking about all the time. They have a letter of rogatory in there as well. And they both are very similar, but there are some very apparent differences in them. So let me read the one that's coming out of creditors and their bonds. This is another example of a letter to a public defender of instructions that you want him to take in your defense on the matter. You got to understand that the public defender is in the public. You're in the private. Public and private do not mix. The reason that they give you a public defender is so he can be your mouthpiece and speak in the public. This is why the attorney's always telling you in court, don't speak. Because if you speak, then you are voluntarily participating in a public controversy, and you can be deemed as a public figure. So let's go into creditors and their bonds. And let's look at some things. This is another letter to an attorney, very similar to the first one I just read. Both of these are available on my website in the PDF section of the website. And we're going to creditors and bonds toward the end of the document. You'll see on page 39 at the back of the document. You will see court process letter to counselor. It's called sample number 7. It's a letter to the counselor. Now, I want you to pay attention to this because now we're going to talk about what a third-party intervener is. Now, this is in Rule 24 of the Federal Rules of Civil Procedure, a third-party intervener. That's what you are. Now, why are you a third-party intervener? You're a third-party intervener because neither of those names on the caption of the pleading are you. We already know that public and private don't mix. So if you're a private citizen and the public, that must be some type of fictitious entity that's on that paper. That fictitious entity represents your property. They're trying to put a lien against your property. Now, you're going to intervene in that matter because your property is in jeopardy. It's in jeopardy. Now, let's read Rule 24 of Federal Rules of Civil Procedure. Let's read that and let's see what it says. Rule 24, intervention. Let's read it. It says intervention. Right on timely motion, the court must permit anyone to intervene who is given an unconditional right to intervene. Okay. Now, we're not going to say Rule 24, but we're going to incorporate some of the language that's in Rule 24 in our document. Now, look at what it says in Rule 24A2. Claims and interests relate to the property or transaction that is subject of the action and is so situated that the disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interests unless exercising existing parties adequately represent that interest. Now, we already know that a public defender, unless you give him an instructions, he's not going to adequately represent your interest. Okay, corpus juris secundii already tells you that he doesn't. He has a duty to the court and a duty to the state that supersedes any duty to you. He's a public defender. He's a public defender, not a private defender. So he's here to protect the public. Okay, so we need to intervene because the disposition of the action as a practical matter will seriously impair or impede your ability to protect your interest. So let's look at this letter of rogatory that's in creditors and their bonds. I wanted you to read this first. I wanted you to actually read the Rule 24 and its language. And now I want you to hear the language that is in this letter of rogatory. This is an instruction letter to the attorney. And I want you to see, can you see where they got the language in this letter from? Now, dear Mr. Public Defender, please take note that I'm claiming an interest relating to the property which is the subject of this action, and I'm so situated that the disposition of the action as a practical matter impair or impede my ability to protect that interest which is not adequately represented by existing parties. So you're telling them right there at the opening sentence, I know you're not going to adequately represent me because you can't. You have a duty to the state and a duty to the public first before you do to me. Okay, you're a public defender and I'm a private man. Okay, so I already know that. Now I need to intervene in the matter because since it's not adequately being protected, my interest in my property could be seriously impaired or impeded against. So it's necessary for me to intervene in this matter. Now, the next is I want to establish a contract with the public defender. So the next sentence is going to say, I accept the kind offer of the U.S. District Court, Southern District of whatever state, on and the date. Now, to find out the date that your public defender was assigned to you, you need to get a copy of the docket sheet. It will have it on the docket sheet, the date that your attorney was appointed to you. All right? So you're going to incorporate that in the language of your letter to him. You say, on September 5th, 2015, the court appointed you as my attorney. I just want you to know that I accept that. Okay? And I'm going to return that to you. Okay? Now, here's what I want you to do. I accept this offer for value, and I am returning it with this notice to you. I now request that you escrow your bar certificate during the course of this case and serve as my counsel in the following manner and only in the following manner. Now, what it is right here is that you don't want him to act as an attorney to defend you. You want him to escrow his bar certificate. I want you to put that away right now. I don't want you to act as an attorney. I only want you to act as a counselor. Now, sometimes on the federal level, they will appoint him as standby counsel, and he will file papers and do all kind of stuff for you as standby counsel. All right? They'll do that. Now, number one, as there is no controversy in this matter, I do not want you to argue any. Now, notice how similar this is to the first letter of rogatory that I read, okay? Now, here's number one. Here's his instructions. As there is no controversy in this matter, I do not want you to argue any facts or public issues as they apply to the defendant. You are not authorized to foster an argument or to join an argument on my behalf or on behalf of the defendant. You're not authorized to defend the defendant. All right, now that's number one. You want this attorney to understand I don't want you to engage them in any arguments. Any arguments are counterproductive to what I'm attempting to achieve. Arguments pull us into trial. Argument of jurisdiction takes you to trial. Arguments that that's not my name on that takes you to trial. Any argument, I'm not under your jurisdiction, I'm traveling to Timbuktu, takes you to trial. Argument that I'm under the Noble Drew Ali Trust and here are my Morris documents and you don't have jurisdiction, takes you to trial. They tried to tell you that in Fury and the Mouse. Anybody know about Alice in Wonderland, Fury and the Mouse? Fury and the Mouse. Y'all know that you know that poem because everything in it, Alice in Wonderland was like a Lewis Carroll's little thing is like it was like a what do you call it? It's making fun of the judicial system. But Fury said to a mouse that he met in the house, "Let us both go to law. I will prosecute you. Come, I'll take no denial. We must have a trial. For really, this morning, I've nothing to do." Said to the mouse, to the cur, "Such a trial deal, sir, with no jury or judge, will be wasting our breath. I'll judge it. I'll be the judge and I'll be the jury," said cunning old Fury. "I'll try the whole matter and condemn you to death." Ain't that what they doing to y'all? You need to read this stuff, and then you need to go investigate Lewis Carroll. You also need to investigate the author of The Wizard of Oz, and you're going to find that these are Masonic people. These are Masons. Do your investigation. Let's keep going. Okay, we're reading a letter of instruction out of creditors and their bonds. Now, let's see what the second thing you want this attorney to do. It says, "For you to stay in honor, I want you to enter this notice into the record by filing it with the clerk of court and by reading it into open court." That's how you get it on the record. "This is notice that I have accepted for value and returned all public offers associated with this matter. And notice that I made every effort to reach settlement through exchange of my exemption for adjustment and set off of the public charges against the defendant. Ask the judge to take mandatory judicial notice of the private agreement that has been reached through offer and acceptance. A copy of the relevant certificate is attached." Now, this is one of the best sentences out of any letter of instruction I've read because right here it's making use of your administrative process. Once you do an administrative process against the attorney and you default him out, you have an agreement. You're going to get the notary to certify that, and you're going to give it to your public defender. That right there is evidencing that there isn't any argument. Like, look, man, I'm not arguing. Here's proof. We already have agreement. We have a stipulation. Here it is right here. I want you to read this into the court, and I don't want you to argue at all. We have an agreement. It's been reached already. There's an estoppel in place. They can't argue anything. I want you to get a copy of the bond that bonds the charges in this matter. If there is no bond in the file, I will provide my bond in its stead. What does this mean? All charges have to be bonded. Okay, this is called a replevin bond. Okay, for someone to arrest you, they have to have some type of insurance that gives assurance that if you are injured, you can be compensated in any way. Now, there is a presumption that everyone in the public is already bonded because they are. They all have bonds blanket bonds, insurance bonds, and things like that. But that hasn't been put on the record in fact. There's only a presumption because an attorney has a bar card number. There's a presumption that he is insured, but that may not necessarily be true. He has to put in a bond. Now, if you want to see this in Georgia, they got to actually have the bond, the law books in Georgia. If you go to Georgia and you go to Title 18, show you what a bond looks like that they're supposed to be putting into court. And if you want to find yours, just Google attachment proceedings in your court, in your jurisdiction, writ of attachment. All right. It's under Title 18 in Georgia, which is debtor and creditor, because it's a debtor and creditor relationship because they're trying to put a lien on you. And it tells you that in OCGA 1711-1. So you need to understand what are the proceedings for debtor-creditor relationships and what are attachment proceedings. All right? Attachment, under general provisions, we have 18-3-19 forms of attachment, and right there you'll see what a bond looks like. And that is in the nature of what is called a replevin bond. They have to put in a bond before they can attach property. A writ of an attachment is a warrant for an arrest and seizure of property. But they have to put in a bond first. So you're asking for the bond. See, the presumption is you're not interested in there being a bond on the case because nobody ever asked about that. And the case is bonded by you starting to argue because now they say, oh, well, we don't need no bond. He's arguing. Look, Your Honor, he's engaging. He's joint issue. 4, I want you to request an appearance bond at no cost to me so I can be released on my own recognizance. Right here, he's asking for an appearance bond in this letter of rogatory too. When the bond has been issued, I will enter a plea of guilty to the facts for the defendant. I will not dispute any of the facts in this matter, but I do not agree to be held personally liable with no protection. So right here, we're pleading guilty to the facts, not to the charges, to the facts. Those statutory charges don't apply to you. You're just letting them know, look, I'm not arguing with you. I'm a private citizen. I'm going to write a check, and I'm going to take care of this. Now leave me alone. You know those statutes don't apply to me, but I'm going to honor the court because I know y'all trying to get money. Y'all need money to keep functioning because y'all are bankrupt. Y'all desperate. Y'all need us. You need our signatures. And if we don't give you our signature voluntarily, you're going to take our dishonor of the system and everything, and you're going to take it involuntarily and hold us as a surety for a debt collection. Put us in prison for hard labor. Let's see what number 5 says in the instructions. After acquiring the appearance bond, I authorize you to use my exemption to bring the accounting of this matter to closure. Request that the prosecuting attorney write the check to close the account and release the bond to the defendant. Now, the bond to the defendant is when we go into court, we ask for the bond. We're asking for the bid bond because I'm giving you my permission to use my bond, to use whatever negotiable instrument I'm giving you, to use exemption. So you have a bond that you're trying to sell. You no longer need that bond. You need to give that back to me because that bond evidence is a debt, and I'm paying the debt. So you need to release the bond to me. Give me the bond. We used to do that in the old school. We used to come into court and ask the judge, where's the bid bond? I'm paying for the case right now. And when you ask them where's the bid bond, watch the expressions on their face. You can ask the attorney in private. Always make sure when you question an attorney, you catch him off guard. Like if he come to see you and everything, you have a question, he's like, y'all just be talking. Yeah, I'm right now I'm going to file a motion for a bond hearing for you, blah, blah, blah. And then you all just catch him while he's talking and say, hey, excuse me, sir, when am I going to get the bid bond? The what? The bid bond, the bond that's bonding the case. Oh, and watch his expression because they ain't never going to admit it. But be looking at his expression, I don't know what you're talking about. Ask a judge that too if you can, if you're defending yourself. Now the bid bond, I'm here to, and the matrix in this because I'm going to, sign this thing and get on out of here because I'm going to accept this. Now, let's look at what it says next in number 6. It says, if for some reason my request for an appearance bond is dishonored, I want you to give notice of my intent to accept the prosecutor's bond for value and to use it to bond the charges, using his bond as surety. His signature is the only one on record as a responsible party. Now, you do know that when that attorney goes and gets an indictment against you, he is gambling. He's gambling because if he loses, he has to pay. And right now, since you haven't made an entry of appearance, they need you to plead into the record so you make an appearance, then he is in jeopardy because he is the responsible party. The liability is on his head. He needs your attorney to make a notice of entry of appearance. You need to check and see if your attorney has made a notice of entry of appearance. Ask him. Because when that attorney makes that notice of entry of appearance, anybody who makes an appearance in the case is liable. And the last person usually to make an appearance in a case is you, and that is usually done by you going into arraignment pleading. Number 7, if necessary, I also want you to give notice of my intent to accept the prosecutor's bond for value and to use it to charge a Chapter 7 involuntary liquidation and start discovery under 11 U.S.C. 1126B. Now, a lot of people were doing this back in the day, filing involuntary bankruptcy. They have changed the involuntary bankruptcy rules. When bankruptcy first came about, it was the creditor who was issuing the bankruptcy against the debtor. Now you have debtors filing bankruptcy. About 95% of all bankruptcies now are filed by the debtor, but it wasn't that way. It used to be the creditor would file the bankruptcy, what's called an involuntary bankruptcy. Only about 5% of the people in this country file involuntary bankruptcy, and those are and where you file bankruptcy against somebody who owes you some money. So if you give him a negotiable instrument and he don't discharge his case, you would file a bankruptcy because you would take him in an adversarial proceeding and you would issue a B-10 proof of claim form, which is an affidavit saying that there's a debt owed, and you'd get him to sign that. There are white people I know who've actually used that. That's how you would get them. You would say, okay, well, since you don't want to discharge the case, I'm going to take you to an involuntary bankruptcy proceeding, and I'm going to bring you into that court. We're going to remove it to that court, and I'm going to give you a B-10 proof of claim form because you're saying you have a claim against me. I want you to sign an affidavit saying that you do. People were getting rid of cases filing involuntary bankruptcy and bankruptcy. This bankruptcy discovery process will locate my remedy and release it to me through liquidation of the delinquent creditor's assets. Now, what's number 8? I want you to make it clear. My intent is to settle this matter in a timely and honorable fashion. And here's the warning. Here's the caveat that you're going to give to the attorney. In the event you, as my fiduciary, dishonor me by not following my instructions, I request that you file a judicial notice of your refusal with the court and file a written appearance in the case. The reason why you want him to file a written appearance in the case because you want him to take on the liability and you want him to tell the court why he's refusing to follow your instructions. And if he doesn't do that, the next time you're in court, you say, Your Honor, you stand up, you speak. You say, Your Honor, counsel is refusing to follow my instructions, therefore counsel is no longer necessary. Counsel is hereby fired. Here are the instructions that I had counsel I wanted him to read, and you read the instructions that you wanted counsel to read and make it a part of the record. That way, you memorialize his dishonor of you. Now, that's it for letters. I hope that you got something from that if you were presently involved in a case. I'm going to be doing webinars on creditors and their bonds. I'm going to do the entire document. They will be $25 webinars. I got y'all spoiled on the $25 webinars. Once again, today is a sale day in case you're just joining us. And you go to my webinar section. All the webinars are half price, all of them. So it's your chance. It's a fire sale. It ends at 12 a.m. tonight, 12 midnight. I'm going to go to the phone lines now. The phone lines are open. You can call in 424-222-5250. Start in Michigan, 313-8214. Michigan, you're on the line. What's on your mind?
Peace. What's going on, you?
What's happening, man? What's going on?
Enjoying the little sun.
Well, what's up, nigga? You got a question or something?
Oh, yeah, I got a question. I thought, you get to talking sometimes. So go ahead and do your thing. Yeah,
go ahead, man. No, go ahead.
No, my question was about when you get the attorney to read or the prosecutor to read the charges into the record when you ask them for the assessment of the charges. that's that when you do that, that's making them show like where they is that like making them show the nature where the nature is coming from.
Yes, it is. See, what it is what one of the things they're trying to hide is that it's commercial in nature. That this is a debt collection. They're hiding it. It's about money. All right, that's why you're asking for bonds and doing all this kind of stuff. Now, there are two ways to handle this. There are situations that you could be involved in where you don't have a public defender. This is why I give people law redemption in court, because now you need to know how to talk in court without giving jurisdiction, when letting them know that you haven't amalgamated yourself to this particular fictitious entity. That's why in any proceeding that I'm in where it's required that I speak, the first thing, I don't care if the judge tells me how you doing today or whatever. You know, the first thing I go into is I am the holder in due course. Here is a third-party intervener making a special appearance as an authorized representative for the defendant. I accept for value, return for value, all the charge and instruments in this matter, and make my exemption as principal available for discharge of all charges and claims in this case. I do not dispute any of the facts in any of the charging instruments. Please use my exemption for offset and adjustment of the public charges against the defendant and release the bond to me or the order of the court to me. Give it to me. All right? I want that, okay? So now when you go in there and you say, Your Honor, I request the judge direct the prosecutor to read the charges into the record. They're operating off of a presumption. Okay, if nobody they in there saying that you did something and nobody read no charges into the record, the person who reads the charges into the record is the liable party. Usually what will happen is if a prosecutor reads it into the record, you'll get another prosecutor not too long after that. They'll start switching up prosecutors on you and judges, because whoever reads those charges into the record is liable. That's the person bringing the claim. So when you're asking them, read the charges into the record, you're saying, who has the claim? Somebody has a claim against me. Who's the person with the claim? You need to come step forward and read it. But a lot of people are pleading to charges that haven't been read. I do this all the time. They say, well, we want to know how you plead. Your Honor, I'll be more than happy to plead if somebody can show me that formal charges have been entered into the record. Do that and watch how nervous they get. You're not saying that. They won't try to enter no plea for you. That'll right there start making them get nervous. So, Your Honor, I'll be more than happy to plead today when you can show me that formal charges have been entered into the record. You can do it like that. Who got the charges? Read them. And they have to do that. They have to do that. They have to do that.
I got another question about when you were speaking about delegation of authority and stuff like that. Now, is it true that when Congress delegates some of their authority to the executive branch, that the executive branch has that authority now and the Congress can't get it back?
No, it's always the Congress can always get it back. No, what it is the executive branch of government now has to follow the dictates of Congress because they're in their house. It's just like if you come to my house, you got your own house and I got my house. If you come in my house, you got to follow my rules. When I come to your house, I got to follow your rules. So what's happening is you got the executive branch of government agents coming into the house of Congress. They got to follow their rules. They got to follow all the rules of Congress. You're not in your own house. When they're in their own house, they can do their own thing. That's why you see them issue executive orders. That's what an executive order is. That's the executive branch government doing their own thing. That's Obama issuing marching orders to all of the agencies that are in the executive branch. He's telling them what to do. And there is some sort of harmony between the branches of government because they are the government. So usually the executive branch enforces the law. So usually he's going to issue some type of executive order to enforce something that Congress has asked him. Now, you will see presidents do this. If they don't like a law that Congress has passed, he'll just not issue an executive order to tell his people to enforce it. Presidents do that. They say, yeah, you can pass that law if you want to, but I ain't giving you no order for you to enforce that bullshit.
Now, I got a question about that then. So, when Congress, the House, and the Senate, they do the bill, right? And the bill, it gets passed. Well, it get passed to the president, and he veto it, said no. But the Congress can come back and say they want it, with the vote, the 2/3 vote.
Yeah, with two-thirds vote, and they can still get it passed. Yeah. And then what will happen is sometimes presidents come back and like that's what Lincoln did. Lincoln, he didn't issue an executive order and enforce something that Congress did, and by the time go back watch that movie Lincoln and pay attention to it. You have to listen to the dialogue in that movie because it's a very, very good movie. And that's what Lincoln did in there. He's like, I won't issue an executive order to enforce it. Now, Congress can bring him up on charges, try to impeach him and do a lot of things, but by the time that happens, go through all the legal processes and all that, he'll already get accomplished what he was trying to accomplish. It was a chess move that they issue against the other branches of government. That's where the checks and balances come from. You know what I'm saying?
Right.
So it's a real interesting play when you really start to study how they get down and everything. But go ahead.
It was the same thing with the Supreme Court, like how they get, they get kind of ran over sometimes with the through the executive or Congress. They get put in certain positions. I know back when Roosevelt when he tried to change he did change the age limit or something for the judges to be sitting on the seat for the Supreme Court, and it made that a lot of opinions were conservative and stuff like that. He was trying to mix the thing up so he could do his thing. So when they do stuff like that, it affects a lot of the structure of government going all the way down. So when we get into
their argument would be that he had to do that under his emergency powers, because the executive branches of government is duty to protect the Constitution and to protect the public. So they'll do it under the statement that, hey, I have to do this because the Constitution is in jeopardy. And, so he'll use his executive powers. Sometimes it will appear that he is going against Congress, but what his argument is going to be, I've been delegated this power under the Constitution for emergency circumstances. So that's, they always act within the ambit of their delegated authority, even if they broadly construe what those powers are. And they do that a lot.
Well, I bring that up because I was looking at the police powers. Now, the Constitution don't give instructions on police powers, but they're using that through the administrative branch.
Yeah, because police powers apply to all of their territory and insular possessions. Listen to the word police. Just like you have the right to police your property, they're policing their property. Okay, they're policing their property. They got a right to do that. And that's why the Constitution doesn't apply. This is what people get confused. The Constitution is a limitation on government. It is a check on the government. Constitution is public law, not private law. It's public law. And when you ask a more of this, I haven't heard one more break down public and private yet. I haven't heard one more say that the Constitution is public law. Not one, even though you can Google this shit. Look it up in a damn law dictionary because they don't know what that means. What does it mean when I say that the Constitution is public law? If you're calling yourself a scholar or something like that, tell me what that means when he says the Constitution is public law. Do you understand what that means? Do you understand the public and private? Do you understand that public law is constitutional law, criminal law, administrative law, public international law, tax law is public law, and the private law is contract law, property law, tort law. This is why somebody will say, well, how do we know the government is a corporation or is a private corporation? Because they entered into a contract, and contract law is private law. Only private entities enter into contracts. It's private law. So anybody dealing with contracts is on the private side. They're acting as some sort of private corporation, private human something. Something about it is private. And you don't have to argue that. All you got to do is look up private law, and you'll see this shit. That's why, I'm like, damn, nigga, have you looked up public law and private law? Do you know the definition of those terms? They won't look it up. They don't want to talk about it. They don't want to talk about it because Yusef the one brought it up. They acting like I'm bringing something new or something. Yusef talking about that public and private bullshit. Like, nigga, that's law. All law is public and private, those dumbass niggas. What you talking about? You just look foolish. You know what I'm saying? I think that's what it is. He's like dumb. You know what I'm saying? It's like that's all law. All law is public or private. You look in the law book, everything they say is public and private. Almost every other word is something public or something private.
And that's, like, I was looking, the reason why I'm asking these questions because I went back to the whole thing with liberty, the word liberty, and what your fundamental rights and your substantial rights are, and, the different types of rights. And of course, I went back to the Sotomayor clip that you played, and I was kind of paying attention to what the Congress was asking her when he was saying, like, is it a fundamental right? And it was based on jurisdiction, but when you get to substantial rights, that's when you can get into strict scrutiny, and that's when you kind of get back on your side, the private side, as in terms to them doing a rational.
Let me ask you something. Let me ask you one. When you say strict scrutiny, what do you think they're strictly scrutinizing?
Well, what I found out is they have two different forms of strict scrutiny. One side is for the public, and one side is for the private.
Right.
So they got two different ways that they use strict scrutiny. And when they do it in public...
Hold on, let me give the definition of strict scrutiny to everybody listening. Strict scrutiny is a form of judicial review that the courts use to determine the constitutionality of certain laws. And that's what they mean. Constitutionality means public. When you hear them say constitutionality of a law, all they're saying is the public staying within the public. Because if they cross that line and go into the private, it is unconstitutional. That's what it means. So they're scrutinizing to see whether you're doing everything private, and they're scrutinizing them to see if they're doing everything public, and that they ain't mixing them.
Yeah, so I was just going into that, and that's what I was just, I was kind of thinking like, damn. And that's the thing, that they cross it all the time, but it's just the way that they do it, with the minimum context.
There has to be a compelling government interest, and that's why it says in the Constitution that private property cannot be taken without just compensation. It does not say that private property cannot be taken. It's that if they're going to take it, they got to justly compensate, and there has to be a compelling government interest. And that's what you need to know. That's where that strict scrutiny comes in. That the compelling government interest, that is what they to determine a compelling government interest, they use the strict scrutiny test. That's what it is. It's compelling government interest.
Now, what is that? What is that compelling government interest on? Is it just commerce alone, or is it,
anything within the gambit of their delegated authority? Yes, I mean anything that they need to further government. You know what I'm saying? Anything they need that falls within the ambit of their delegated authority, to ensure the continuity of the republic and the government.
Okay, but how does that affect you on the individual? Like every case isn't every case is not a thing to where you would. It's more or less they don't want to make a decision on a certain case because it'll change things. Is what it sounds like to me. I don't think that it's particularly like a individual case that it's just so compelling where they have to do you in. It's more or less that if they make a decision on your case, then they'll have to change some things. So is that what they mean by compelling state interest or compelling public interest?
Yeah, they got a compelling government interest. I'm going to read you the definition. Is a concept in law that allows the government to regulate a given matter. For instance, there has been held to be a compelling government interest in restricting access to unapproved drugs. Now, why would the government regulate drugs? Because drugs are artificial. Everything, and this is what I want people to think about too, because everything in nature has two sides. There is something natural and there is something artificial. All right, and this is how I've broken. This is the easiest way I can break it down in my mind. Everything natural is from God. Everything artificial is from the devil. I'm just going to use it like that. Okay, and the devil is warring with God through using artificial things. So instead of you putting natural things in your body, which they don't regulate because the government can't regulate any of that, you put drugs in your body, which the government can't regulate because it's artificial. They regulate anything that is artificial, that is man-made, that they have made. That is the only thing they can regulate is the things that they have made, because the things that God has given us, God has laws that regulate that. And you need to find out what those laws. Now, what they will do is that they will sometimes codify some of God's laws. You will find some of God's laws in the statutes. They'll codify them because that's what they do. They codify law, common law. You'll see it reflected in the statutory law. You'll see that a lot. But a compelling government interest is usually some type of interest they had over something that they have created, they have made, whether it be corporations, corporate-related activity, anything dealing with Federal Reserve notes, all right, anything dealing with that, they have a compelling public interest on that. Anything that's dealing with their territories, anything dealing with their creations, anything that's coming out of Article 1, Section 8, which is where they get their delegation of a lawmaking authority for the statutes for Congress. So these are compelling public interests. Now, and you have to read some case law. Right. I will admit that when you read some Supreme Court law, you'll see where the judges do a dance. Now, judge can be deceptive, and because judges make law. That's what's called judge-made law, because they construe the law. The legislative branch creates the law, the executive branch enforces the law, and the judicial branch interprets the law. So they can make law by construing or interpreting something that may not have been originally the intent of Congress. Now, you will always hear them say that they are supposed to try to get the intent of Congress, which I think is poor legislation when they have to do that. Congress should make whatever they're saying very clear and cogent, but they don't always do that. They got this vague and, type of legislation that comes down and everything. You don't really understand who it applies to or what it applies for or what it's for and everything. And then you got now to spring up all of these court cases, because now the judges are going to have to construe that law and find out what the intent of Congress was. And then that's when you get the case law.
Exactly, and that's why I was saying about strict scrutiny. So if they do those cases by strict scrutiny, then that pretty much will that should pull out the intent of what that particular statute or act, you know what I'm saying, is who it applies to. Right. They should.
They're supposed to. As a matter of fact, in some of the paperwork that we send to the government officials, you put that in there that, it's like, only law I'm subject to is the laws that you clearly state in there that it applies to us, the general public. And they don't ever do that. They don't ever tell you, well, who does this apply to? And that's why you got to read your state constitutions and everything, because most of the people are confused. Everybody thinks that a statute is a law. Let me read something to you. Hold on for a second. I'm going to get a book. Hold on. Okay, I'm back. I got this book. It's called State Government. It's by Bates and Fields, and I found it in a used bookstore. And it is an excellent book. It just talks about scope of powers. I mean, it's breaking down government, use of taxation, territorially. I mean, it explains everything: republic, monarchy, the head of state, administrative, judicial, executive. Breaks down everything. Aristocrat. I mean, this thing is a bad book. But in here, they got a thing in here to talk about statutes. Silence of Congress, expansion of power, police power and interstate commerce, personal freedom. Right of suffrage, due process. Where is this? Wait, let me find this thing. Talk about statutes. And I'm going to read this to you. Fascist, got sovereignty in here. Separation of powers. Monarchy. Federalism. Implied powers, scope of powers. Where is this thing at? Exclude state functions. To conduct federal elections, conditions and admissions. To consider amendments, aid in suppressing. Declaration of war, immunity from suit. States may not control currency. Privateering. Import-export, bills of credit. Silence of Congress, expansion power. Where's this thing at? Hold on. Property, liberty, obligation of contracts, law enforcement, civil defense. Okay, state debts and increasing compact for full faith and credit clause. Even talk, I got to go back and read some of this. This is like, I'm seeing some very interesting stuff in here. Look at this right. It said corporations are not citizens of a state within in the clause of the Constitution. Conflicts of laws, which is international law. Statute law, here it is. Okay. Law professor.
Hey, so you starting to break up now.
Can everybody hear me okay? They scan it and put it in PDF format. I know I've been looking for this book in PDF format and I can't find it. But it is a very, very good book. And it tells you in it that statutes in the field of commercial law, the conference had its first success in negotiable instruments. And it tells you in there that statutes are not laws. It talks about how it applies to the agencies and so forth. I'm going to find it. I don't want to take up too much time. I thought it was in the... It's a real nice book. That's probably one of the best books that I've got. But the name of the book is called State...
I just tried to look it up on Amazon. It's unavailable.
It's an old book. It's put out by Harper Publishing. But it's an old book. But I mean, it is very well written. And it's in Department of Government, Indiana University, Harper Brothers Publishers, New York. And it was first copyrighted in 1928. 1928. So I found this in a real old bookstore, but it's a real good book. Breaking it out. Everybody's I'm getting choppy now. But hey, let me take a couple more calls, man. Let me take some more calls. A lot of people want to ask questions. But that was a good little bit colloquy. Because they were colloquy. They use the word colloquy on y'all in court. 912-8789. You're on the air. 912-8789. Shalom.
Shalom, my Can you hear me, brother?
What's going on? I can hear you. Yeah, loud and clear.
First of all, the Most High Yah for you and all that you are doing and all that you are teaching, because you are unveiling the trap that traps my brothers while they make money off us on football fields and basketball courts, and we win every war for them. I just want to say thank you. And you speaking French while English at the same time, for real. And we try to understand the best we can, but I'm telling you, you be like, yeah, you notify the ability of the parlez-vous français. I'm like, what? So I'm just continuing to listen, and I'm going to invest in the knowledge that the Bible says buy truth and do not sell it. So I'm going to do that as well. But I have a couple questions. Got some cases, man. First of all, I want to own the right to everything that I create. And apparently I'm a citizen, and I didn't want to be. And I don't know that process. So I need to know from scratch. I'm just some dude who's like, hey, hit this link. And I heard something, and this dude's making sense. And he was like the most gangster nerd I ever heard of in my life, and it was cool. It just felt right. So I don't know what to do from point zero to where I need to be. So what's the first documents I need to get? I know something about a secured party credit. I'm trying to get
the most important document you can get to start off is a copy of your birth certificate, the long form.
I'm
copy
sorry.
of your birth certificate. Your birth certificate.
You're coming in a little choppy. It's hard to fully understand clearly as it was.
I don't know what's happening. Hold on, I'm going to change it. Give me a second.
Yeah.
I don't want y'all to hear this.
Long form birth certificate.
Give me just a second.
Yes, sir. Take your turn.
All right, can you hear me now?
Yeah, man. Super straight. Yeah.
Okay.
All right, so
All right.
long birth.
First thing you want to the first thing you want to do is get the long form of your birth certificate and get that authenticated. All right. And then you want to start going through a process where you're going to start to give notices to the government agents. You know, they're operating under a presumption, and they have a right to operate under a presumption because, you know, you've never formally informed anybody of what status you're desirous to be looked under. You know what I'm saying? You just assuming that, well, you're a welfare recipient. You know, you're taking benefits and privileges from the government. So the first thing you want to do is also adjust your conduct and start to understand that you need to stop taking benefits and privileges from the government. You need to stop using that Social Security number for anything. All right? That too is a very, very big thing that you're doing. You got to stop, and that's challenging, especially to a person who's lived all their life working for someone else. It's very challenging. However, it's not impossible. The first thing you can do is you can start, like yesterday, I was on real estate investment. This dude was showing how you can do real estate on your computer and not even leave the house. And he gave a free webinar. A free webinar. So you can start doing things like that to, you know, you got to start studying things. Like for me, you know, one of the things is I had to start studying real estate and do different things like that to develop some sort of skill for myself that will allow me to work for myself, and then I need to take the appropriate action. All right? Then I would say the first thing in working for yourself that you have to do is you have to have a big vision. You have to start clearly seeing and stating to yourself what it is that you want to do. This is the spiritual aspect of it. You have to start asking God for what it is that you want, and then having faith that you're going to receive that. So it's like you got to start. It's a process. It's a process, but you got to get away from that Social Security number. That Social Security number is the mark of the beast.
Yes, it is. I read that, USC 42666. May I interject really quickly and ask you something?
Go ahead.
I didn't get the name of the real estate investor, but my heart wants to do that. I am working for myself, plus I believe I'm one of the best. I should say, that I'm one of the best singers in the world. So this is the information that I'm going to sing about. And so I have a business and all that's working, but I'm a combat veteran, like a lot of my brothers in this group, and they receive benefits from this situation to be able to live. This income hasn't taken over the other income to make this switch, so then we'd have no, you see what I'm saying? I'm trying to find the access route. If we stop using this number that you say.
I understand what you're saying, but here's the thing, man. First of all, you got to have some faith. There's nothing to fear. Okay, you don't have to fear these people in any kind of way, and it is a step-by-step process. You have to begin to educate yourself slowly. Nothing can be accomplished overnight. When you listen to me on the radio, I've been doing this for 10 years, day in and day out. There has not been one single day in 10 years that I've not been reading or studying something about this information. So you're looking at a person who's been doing this a long time. So don't expect to have it locked down the way that I do. But you yourself, just take a little bit. A house is built one brick at a time. Every day, get a little bit here. This is why I've been starting to do my shows now. I'm starting to concentrate my shows. Like I'm doing shows, okay, today I'm just going to talk about a bond. All right, this day right here, I'm just going to talk about the public defender. I'm trying to chop it up in little bitty pieces for people, and then they can begin to get the whole picture and everything, because, just try to throw everything at everybody at one time, that's not going to be good. So right now, concentrate on authenticating the birth certificate, all right? Concentrate on that. Master that. Once you get that understood, then you may want to try a secure party process, okay? And in the secure party process, you may want to say, okay, the first thing I'm going to do is I'm going to learn how to file a proper UCC1 and a UCC1 addendum, or non-UCC, or whatever it is that you want to do. Okay, then I'm going to learn what does this tax-exempt or this affidavit of tax-exempt status really mean? Why am I sending this to the government? Why am I filling out a Form WA, which is a certificate of foreign status? Why am I doing that? Just work with a couple of documents at a time and break it up into little bitty pieces, and then the whole picture will begin to emerge. But don't try to overwhelm yourself thinking in your mind, I got to understand all of this. The first thing you want to do, after you authenticate that birth certificate, the next thing I would do is write a letter to my governor in my own words and say something to the effect, look, and read your state constitution too. You have a responsibility to read your constitution. You have no business calling in on this show or living in a state and you haven't read your state constitution. You need to read that, read your constitution, and say, look, in my state constitution it says I'm going to be afforded these rights, and it also states that if I don't have a written express contract with you, I'm not subject to your oversight. And I just want to let you know in a written correspondence that how I'm going to, my intentions, which are honorable, and that I am not going to be engaged in using my automobile for profit, for commercial profit or gain on the public highways. And I would really appreciate if you would put me on a do not detain list and don't start molesting me while I'm traveling in my private capacity. You know, something to that effect. Start putting these people on notice. That's the first step you got to do. Start correspond. There's a reason we're supposed to be corresponding with these people, letting them know what your rights are, that you understand what your rights are. And you read the Constitution because this is where they get their power from. Okay, even this corporation, everybody keeps trying to say that the corporations have usurped the republic. No, the corporations got their authority to come into existence on the federal level through Article 1, Section 8, Clause 17 of the Organic Constitution. All right? This is parliamentary law. Under parliamentary law, they can create a constitution, can be considered a bylaw of a corporation. All right? So they just called it the U.S. Constitution. All right? They just took all of the elements in the Organic Constitution and incorporated it into theirs. And it's very deceptive. But once you understand, but it's well within the ambit of their delegated authority. Well within. Go ahead.
No, I was just in agreement. I'm tracking, sir. You said loan birth certificate, notice to the agent, then file a UCC, write a letter to the government, my own words stating that I don't work for them, read my Constitution ASAP. But one other thing, I got 2 cases. Same thing, you know, same track. Once I was pulled over, this police officer didn't like me, so he used that as an excuse to try me later on. My vehicle ran out of gas. He ran up behind me and said, hey, you ain't got insurance, took me to jail for it. There's no insurance on the vehicle. Took me to jail. He told me to force you here in jail. In Georgia, this is slave state, so they force you. He was trying to force me to sign some paperwork, and I had heard one of these things y'all said about, say, under duress. So I wrote that on the paperwork, and the people been mad at me, let me out of jail. Then they never gave me a court case. I've just been waiting. I called them. I put an affidavit in. Hey, what am I doing here? What's going on? Can I get some kind of relief? Because I lost money. You know, I lost a lot of things going this.
But they never gave you a court case. They don't have no contract with you. They don't have no contract with you. And you can put coactus specie under there because they will do that in Georgia. Trust me, I'm in Georgia. I know exactly what you mean. You know, because they say, well, Yusef told me to sign like this. You know, I've had officers stand over me and see me sign something a certain way. Like I put like UCC 1308, he balled it up. You know, he balled up the paper and he told me, he said, man, look, you sign that on that paper, you ain't never getting out of jail. You know, they threatening me and everything. You know, so then that's when you got to get creative. You need to know how to do what they call ellipses, and you can put 3 ellipses in front of your name. That lets you know that there was something that you were trying to say, but you weren't able to say it because somebody was standing over you. You can sign a coactus specie in Latin. You know, there's a number of different things that you can do, you know, to try to, like, little slick things that you can put by your name that may not be that noticeable that, you know, when you're in a situation like that where somebody's trying to get you to sign something a certain kind of way. But you want to be, if you they can't force you into a contract. Everything in their system has to be voluntary. They need what's called your voluntary consent. And if they don't get that, they don't have nothing. It's voluntary. Their whole system is based off voluntary. Slavery exists in this country through voluntary. Involuntary servitude cannot be permitted. So if involuntary servitude is not permitted, then it must be voluntary. You know what I'm saying? If you're in servitude.
Hold on. So all my family in jail because they ain't know no better and volunteered themselves in prisons and destroying families, and our situation is in hip-hop because we voluntarily walked into a jail all because my people perish for the lack of knowledge.
Knowledge, and you know what? Being ignorant is a choice. That's your voluntary consent. You're a choice. You know, and they got this paper called Silent Weapons for Quiet Wars. And in there it says people who do not choose their brain, people who choose not to use their brain are stakes on the table by voluntary consent. If you choose not to use your mind that the creator of the boundless universe gave you, if you choose not to exercise it, if you choose not to expand it, if you choose not to utilize the greatest gift that the creator has ever given, that will ever give you, then you have chosen to be a slave. Because, let me tell you something, the subconscious mind is always at work. Either you're going to program it or somebody else is going to program it. Your subconscious mind is a female, it's feminine. And your job is to protect, as a male, the masculine principle protects and provides to the feminine principle. The masculine principle is the conscious mind, the feminine principle is subconscious. And if you are not protecting your subconscious mind, then there are going to be other people with masculine principles that's going to come and impregnate your woman, which is your subconscious mind, because you're not doing your job of protecting.
Educated. I'm tracking. Okay. Yeah, that's cool, man. All right. Hallelujah.
I'm sorry, did you hear me? Did I go out? Did you hear what I said?
Yeah.
I know I went out.
You blinked in and out a couple times, but
it's your mind. It's all about your mind. Everything in law is about the mind. That's why they have a thing called criminal intent. All right? Criminal intent is the mind, and there's a law that says if the mind is guilty, then you are guilty. You cannot be guilty unless your mind is guilty. If your mind is not guilty, you cannot be guilty. And how you determine if the mind is guilty, they do what's called a cross-examination, which is an examination of your subconscious mind, which cannot lie. That's why they call it ma'at, truth. Ma'at is truth. The subconscious cannot lie. It can't lie.
Cool. So, question, another one before I go. I know the people behind me. Do you have this whole process in webinar format in numerical order?
Yes, I do. You can go, first of all, you can go to my website for free, and you can get a PDF. It's called a Secure Party PDF. It's under the you can go to highfrequencyradionetwork.com and hit on the PDF tab, and then look under the commercial heading, and you'll see all the different books I have on there. And you can download those. They're on no cost. They're all free. All right, and you can download the Secure Party Manual, all right, which outlines everything step by step for you. And then I have a webinar on there too. You can have a webinar link, and I got hours and hours of webinars where I demonstrate and show you how to do all of this stuff. And today would be a very good day to get it because I did a Labor Day sale today, and everything is half price.
Cousin, I already got you. I'm already, Anyway, the Most High Yah is good is what I asked for. Because I got these court cases. I got 1 in 2 days. Oh, another court case before I go. I get pulled over. They say, oh, you were speeding, being real jerkish. I recorded all of it on my phone. And I asked him, hey, sir, what's the emergency? I had an emergency. I was driving to see my children. I had to go see my children. Like a pregnant woman in a car. She's about to have a baby. You speed. I know you say you can't speed, but sometimes you speed. So I'm telling the officer. He being, I'm the number 2 officer here. He does all this stuff to throw me in jail. And I got it all on the record. I don't know how to put it on the record. I don't know how to cancel the case and then establish the remedy for the wrong deed that they done. That makes sense?
Yeah, it makes sense. And wait a minute. Can we say the last part again? I didn't catch the last part. They did what?
I'm trying to figure out how to, he took me to jail for having no license or registration on a rental vehicle, and I had license or registration on a rental vehicle, and he was just being a nasty jerk about it. Even though I'm telling him, I got
you don't got no affidavit telling your side of the story. I mean, here's the thing. You can't ever, we say, well, they've been a nasty jerk and things like that, and the thing is that you can't never tell another man how he sees things. Another man may see something entirely different how you see it. You got your way of seeing things. Another person got their perception on how they see things. This is why there's no such thing as facts in court. There's only stipulations. It's what you agree on. If you agree on the truth, it ain't your truth and somebody else's truth. It's two different things. Your truth and somebody else's truth are two different things, all right? So, you know what, everybody has their own perception of reality and what the truth is. There's your truth, yes, their truth, and then the truth. And in court, everything revolves around agreements. And this is why it says in the Bible in Matthew 5:25, agree with your adversary before you get to court. Because if you go in there arguing, then we have to determine who's lying. And you're going to do that through fact-finding. Because it's your perception of what happened, and then he has the perception of what happened.
And I don't want to do that. I just want to go in there and agree.
And you don't want to do that. You want to reach an. The reason you want to do that is because they are corporations. They are fictitious entities. There's no need to argue with them because you are the creditor. They are trying to access your trust account. You can give them permission to do that and then tell them to get the hell on because everything that they're doing is about debt collection, and there is no money. Right? They can't get gold or silver or anything from you. The only thing they can take from you is a negotiable instrument. So why argue with them? There's no need to engage them in any type of controversy whatsoever. Just pay it. Pay it with your signature and tell them to go on.
So I need to do an affidavit of my in a couple of days or a week.
You can do that, yeah. You can do an affidavit. You can put together a little package, an affidavit outlining what happened, and then an affidavit about your status, and then you can send them a negotiable instrument. Also, I mean, you get creative with it, you know, get very creative. I have done things where I put in an affidavit for people of what happened, and the case goes away just doing that. Because most of the time, the average person out there, when they get arrested, they don't have no affidavit put in. They get an attorney, they don't do nothing. You don't have any fact. The police got the affidavit because the warrant is an affidavit. All right, he got a police report. He got all that. You ain't got nothing. You just coming in talking about what somebody did to you. Right. You know what I'm saying? You don't got anything in the record, ain't no evidence in the evidence file, nothing to substantiate your claim. But they got all the paperwork substantiating theirs, and you got nothing but your mouth coming in talking about what somebody did to you, how wrong they were, how evil they are, and all this right here. And what a piece of shit the prosecutor is. You got all this, but you ain't got nothing to substantiate to substantiate that you have a stipulation with the opposing party as to what the facts are.
Right. Well, brother, wherever hours it is, it's PDF. I ain't gonna front. I already got some of your PDFs.
And you can listen to this. You know, I spent all day today. This was like a webinar today. I spent all day explaining this today. That's what this show was for, to explain to y'all what's going on. But hey, look, I got to take another call, brother. I got about 11 minutes to the hour. Got a whole bunch of people online. I appreciate the call, okay?
So you will have a wonderful day. Shalom, shalom.
Shalom, brother. Shalom. All right. 225-4933 on High Frequency Radio. Question or comment? 225. Okay. 757-9044. You're on High Frequency Radio. Seven 773-1958.
773-1958. That's my number. What's up, Yusef?
Hey, what's going on? How you doing?
Man, my brother. Okay. Because, I said, it's my number. Okay, check this out. I got three things.
All right.
One thing, case docket and case file. There's a difference between a case docket and a case file?
No, docket sheet. A docket sheet outlines everything that's been filed on the case, and then you got an evidence file that is reflected in the docket sheet. I mean, I guess they could be considered similar, but the file is the actual paperwork that's stamped and copied. When you go down to the clerk's court, you're gonna get the file. You can ask for a copy of your file, and they'll hand you the actual paperwork. The docket sheet is just basically shows everything that's been going on with the case. So the docket sheet is.
Clerk, I go down clerk's court to get the file, extra file. Okay, check this out. I'm in a fair situation. I've been in it for like a year. I think you're familiar, I don't know. But what happened, the first judge, he recused himself. One of the co-defendants issued a $40 million bond. 90 days over, he recused, assigned to another judge. All right. So back in September, we had trial set for September this month, like 29. And what happened was the sister issued another milli bond. She has a $40 million bond against the case with this new judge. Now, I get a call last week. The prosecutor had changed the prosecutor, and they changed the trial date.
I told you they're going to change them out, yeah.
So
they keep changing out because the person you bonding up, the new person not bonded. So you got to keep bonding it. You got to keep bonding it for the new person. That's why they changed it up, because they changed judges and prosecutors, because then they got a new prosecutor. He ain't got, he ain't bonded up. That's why they changed. They be flip-flopping like that on you, trying to get you,
You just got to keep on doing that, until they stop. Or
you keep bonding them, man. Because every time they could be giving you new cases, you don't know what's going on. They could be switching up because they're trying to get money. They're trying to get more money. Like, damn, he's giving out $40 million bonds. Let me get one. You know what I'm saying? You never know. You know what I'm saying? You don't know what's going on behind the scenes, man. Everything that they do is a stage play. You never know what's really going on with it because it's all a front. Everything is a play. That's why the fourth rule is do not participate in public plays. It's all a play. It's all a play. They are not who they appear to be. They're not who they're posturing themselves to be. But it is about commerce, and they will keep trying to flip-flop, people on you because, if you bond the case with one prosecutor, they brought in another one. He don't have anything to do with that. And then they might even slightly change the case numbers a little bit. You got to be careful about that. The letters at the back of the case represent the judge. Those are the initials of the judge. So then they'll change the judge, and then really the case number changes. You see what I'm saying?
Okay.
You got to pay attention to all of that.
One quick thing I want to let you go. I appreciate your response. The indictment itself, I know a trained eye will see the flaw in the error in the situation. A trained eye would know, and I don't have that trained eye just as yet. Now, the true bill that's in the indictment, there's no signature on the true bill.
Don't be having that, and they're required to have that. And let me read that to you. And also the grand jury foreman. I'm down with somebody right now. They got in the grand jury foreman. I mean, these people be tripping. I mean, you start looking at it, I'm like, man, nobody found this shit. How you got any? There ain't no charges against you. I estimate that 30 to 40% of indictments of people who are in prison is not even signed. Not even signed. And they do that because they don't want the liability in case people find out. But it's like if you go to United States Code indictments, if you go to 18 U.S.C. Hold on, let me see. Federal indictment.
Yeah, Grand Foreign Journal. There's no signature. I said, man, I saw that. I said, something's wrong here. And I can't. I know something's wrong. I can't put my hand on it. And I said, trained eye will be able to see that right off.
Well, I'm gonna tell you what you're supposed to do. If it's not signed, you're supposed to do an abatement. All right, you abate it. You don't do anything because that's procedurally. It's procedurally incorrect. When they don't. When they don't. Do it. So you don't need to do anything but just abate it because. Now you go to 18 U.S.C. 3161. Let's see. Any information? Okay. Any information or indictment charging an individual with the commission of an offense should be filed within 30 days from the date of which such individual was arrested or served with a summons in connection with such charges. Let's see. Contains the defendant is to be tried upon an indictment information. Let me see. Trying to find it. It talks about indictment and information.
Well, the sake of our call, I try to drop you an email in and say, per the heading, something to the very respect, and you could probably email me back that, what you're trying to find.
Yeah. Yeah, look up Rule 7. Rule 7 is the indictment and the information on the federal rules. And it tells the nature and contents. In general, the indictment or information must be a plain, concise, and definite written statement of the essential facts constituting the offense charge and must be signed by an attorney for the government. All right, it must be signed. So that's Rule 7. So procedurally, if you took up Rule 7 and go to C, which is nature and contents of the indictment and information, you'll see right there it tells you that they have to sign it. So if it's not signed, then that is procedurally incorrect, and that means an indictment is in order because you ain't signed it. And what they're doing is they're trying to escape liability because there's a requirement that they bond the case. If they don't sign the indictment, then they don't have to put up no bond. And then you get in there and start pleading. It's your responsibility to review the indictment to make sure it's signed. You know? But most people depend on an attorney, and the attorney never, ever points that out. I ain't never heard an attorney point out, well, your indictment's not signed. They don't ever do it. So there it is right there. So it's Rule 7, okay?
Thank you. Okay, peace, God. I yield.
You're welcome, bro. All right. Okay. I got 3 minutes left. I will be on tomorrow morning at 8 o'clock. All right.